Senator Hedelman, we're just waiting for a quorum here and then we'll get started very shortly. All right, we're just waiting for a couple members to come by before we can get a quorum to start the committee. So just hold fast. Thank you for your patience.
Sounds like some dad jokes.
All right, so you're going to suffer through a couple dad jokes with me then. Oh, here we go. Oh, you saved from the dad jokes. I hear you. I hear you. Well, I'll give a self-deprecating dad joke anyway, just to, is that okay with you all? All right. Why did Will Smith slap Chris Rock with an open hand? Because paper beats rock. Oh. How do you find Will Smith in the snow? You follow the Fresh Prince. Oof. All right, that was bad. All right, we're gonna gavel in. All right. All right, Senator West.
So why did the chick disappoint his mother? Because he wasn't what he was all cracked up to be.
Oh. A guy tried selling me a coffin the other day. I said, that's the last thing I need. All right. We're done. All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 7th. We have 14 bills on the docket. We're going to start off with Senator Heddleman with Senate Bill 134. We're then going to go to Senator Heddleman again with 128, 132, 71, 402, 36, 139, 174, 85, 400, 89, 182, 187, and we'll end up with Senator Kelly. Actually, that's probably going to get pulled from the list, but we'll end up with Senate Bill 390. So without further ado, Senator Heddleman, welcome back to JPR. Senate Bill 134, the floor is yours.
And may I say, I think you guys are great at your day jobs.
Some people don't think that that's the case either. So
good afternoon, everyone. Mr. Chairman, Mr. Vice Chairman, members of the committee. It's good to be back in JPR. My name is Shelley Heddleman, and I am here to present Senate Bill 134, which would create an Office of the Correctional Ombudsman. This is a topic that is familiar to this committee, although we come to you this year with a slightly new and improved version. The need for independent oversight within the correctional facilities in Maryland is long overdue. The current system of oversight and accountability within the Department of Public Safety and Correctional Services is insufficient to deal with the myriad of issues arising behind bars. This bill creates an Office of the Correctional Ombudsman it comes to you, creating it within the Office of the Attorney General. You should have some amendments before you that would create an ombudsman office that was an independent office. And actually the Attorney General is generously here who can explain why that is important. This office would provide needed independent oversight of the adult correction system while improving safety and other conditions inside of Maryland prisons. In response to the Attorney General's belief that this office should not fall within the responsibility of his agency, we believe it should be a separate unit of government. More than a third of the states in this country, as well as the District of Columbia, have an independent prison oversight body. And our neighbor to the south, Virginia, recently established its ombudsman office in 2023. They actually have it set up so that they have a state office of ombudsmen and that go across state government, and other states have that as well. We do not have that system. We kind of have embedded our ombudsman when we have them within our state agencies. Reporting from several of these offices, and you will hear today about the experience of another neighboring state, New Jersey. We have Mr. Terry Schuster here, who is the ombudsman from New Jersey, to share with us that state's experience. These offices have resulted in improvements to prisons as well as clarity on conditions for incarcerated individuals. You have in your written testimony numerous examples from people who were formerly incarcerated about their experiences behind bars. And they have shared with you and with me significant concerns they have in the current reporting system and the current system that is set up to remedy those complaints and address them, including for multiple women housed at the Maryland Correctional Institution for Women from last year's hearing. And additionally, a correctional officer at ECI, Eastern Correctional Institution, was recently charged for allegedly destroying evidence of an inmate's abuse by another officer and lying to federal authorities about the incident. There are no shortage of circumstances that warrant further review. And this office would provide the oversight to better improve the opportunity of such inmates' complaints being investigated by an independent party. The bill establishes procedures and reporting mechanisms for addressing concerns and promoting transparency within Maryland's prisons. The Office of the Correctional Ombudsman would be responsible for investigating complaints concerning incarcerated persons' health, safety, welfare, and rights, providing pertinent information to prisoners and their families, identifying and publicizing pervasive systemic issues, and monitoring DPSCS compliance with relevant statutes and policies. Currently, only written or typed grievance letters are accepted from incarcerated people who may be delivering complaints to the very officials about whom they're complaining. Each appeal of the grievance letter must go through multiple levels of review that are costly, cumbersome, and can take literally years to be addressed. The Correctional Ombudsman will have the power and authority to go straight to the problem, cut through the bureaucracy, and address it immediately. This will save the state and taxpayers thousands of dollars by reducing jail condition-related litigation costs. A wonderful coalition of legislators and advocates have consistently worked to improve and tailor this legislation, culminating in today's Senate Bill 134. Previous bills have proposed to pattern it after the JJMU, the Juvenile Justice Monitoring Unit. It really is a different sort of body. That body is tasked with making reports and to us quarterly investigating juvenile justice institutions, whereas this office would perform more investigative responsibilities. We believe that by establishing the office, Maryland would join other states in practicing good government, providing an independent ombudsman to publicly report on and make recommendations to improve our correctional facilities. I urge a favorable report on 134, and I am very thankful to have here with us today the Attorney General, who has been very supportive of this legislation, and and the Public Defender, Natasha Dartig, as well as Olinda Moyd, who is an advocate and a professor of law, an advocate with Major, Maryland Alliance for Justice Reform, and as I stated, Terry Schuster, the Ombudsman from New Jersey. So thank you very much, and I'm happy to answer any questions if they.
We're going to take questions after your sponsor panel. So
Great.
Thank you very much, Senator. Attorney General.
Thank you, Mr. Chairman and Vice Chairman Walt Stryker, members of the Judicial Proceedings Committee. I'd like to see my Senator Nick Charles. Congratulations on your move move over to the State Senate. Haven't spent 8 years in the House, but no, it's a pleasure to be here and to testify. I'm Anthony Brown, Attorney General of Maryland, for the record, to testify in support, with amendment, Senate Bill 134. I want to thank Senator Hedelman for her leadership, not only on this bill, but her commitment to improving the correctional system to better serve our incarcerated population, their families, and the people of Maryland. I want to thank the advocates for their commitment, the passion, the insight, and the experience that they bring to this issue. As Senator Hedelman outlined, the Senate Bill 134 seeks to establish an independent oversight of Maryland's correctional system. And I think the need for transparency and accountability, it's been well documented. We've got a closed environment in our correctional system that needs some significant oversight if we're going to improve conditions for those who we incarcerate. Senator Hedelman has provided ample justification for the bill. You'll hear from others as well. I'd point out that I submitted written testimony, and so I only want to hit the highlights of that, and I would ask you to review my written testimony. I'm here primarily to talk about the independent part of an independent correctional ombudsman. Senate Bill 134 is currently drafted does not provide a truly independent correctional ombudsman for the simple reason that as currently drafted, the office would be in the Office of the Attorney General. And I am the same office as the Chief Legal Officer that provides advice and counsel and represents the very department, the Department of Public Safety and Correctional Services, that would be on the other end of these investigations. So it is our position, and shared by Senator Heddleman, I think the vast majority of the advocates, that the more effective approach, it's not a cost issue, it really isn't, but to eliminate and reduce conflicts between the department's counsel and the oversight entity would be to create a separate unit of government. And that's what the amendments reflect. As you know, there are 15,000 plus individuals who are incarcerated in the facilities of the Department of Public Safety and Correctional Services. This is an environment in which the facilities exercise total authority over incarcerated persons, their health and well-being, access to educational and other programming, their communications with their families in the outside world, whether it's telephonic or whether it's email or whether it's in person. And so as a result, you can imagine the complaints are equally complex. And I've attached to my written testimony some samples, some samples of the types of complaints that we already receive from incarcerated persons. And I think Senator Heddleman mentioned that she has provided you with some as well. The complaints are often complex. They involve multiple allegations, often multiple employees at the department. And under the current bill as drafted, I would be required to investigate and determine the legality of any departmental action, decision, adjudication, failure to act, omission, rule, regulation, interpretation, recommendation. The list goes on. You can imagine the conflict that creates for the Office of the Attorney General should the Ombudsman be located and under the supervision of the Attorney General. Some may ask, well, can you not erect ethical walls? And we do on a regular basis. But the volume of complaints, and it's hard to say exactly what that volume would be. You can look at the experience in some states. It ranges to a few hundred to a few thousand. Would make it nearly impossible to erect ethical walls that enable me to deconflict these competing responsibilities and obligations, not to speak of, I think, the severe damage that it could do to the attorney-client relationship between the Attorney General and the department. I provided links to 2 surveys in my written testimony, one conducted by the Brennan Center, the other by the Natural Resources Center for Correctional Oversight. You'll see in those surveys, at least 20 states have established an independent office of correctional ombudsman. Some have put it in the governor's office. Some have put it, have created as a independent unit of government, and that's the amendment that you have in front of you. Some, while I don't know if you necessarily want it, have put it in the equivalent of Maryland's Department of Legislative Services, but all have created them independent of both the Department of Corrections and the attorney who represents them. The only state where there's a slight nexus between the ombudsman and the OAG is in Hawaii, and that's expressly laid out as for administrative purposes only. And in fact, I think you'll hear in New Jersey, their Treasury Department supports their independent office for administrative purposes only. So we support the correctional ombudsman. We think it's long overdue, and we think by adopting the amendments that we propose and that's acceptable to the sponsor, it'll make for a stronger independent office. So we strongly urge the adoption, a favorable report on Senate Bill 134 with amendments. Thank you, Mr. Chairman.
Excellent. Thank you very much, General Brown. We'll now hear from our public defender.
Good afternoon, Mr. Chair, Mr. Vice Chair, distinguished members of the committee. I am Natasha Dartigue, Maryland State Public Defender. And I am here today to affirmatively state that the Office of the Public Defender is in support of Senate Bill 134 and request that this committee return a favorable report. Thank you, Senator Hedelman. As this bill is long overdue, we must take a closer look as to confinement at every single level. We cannot continue to turn a blind eye to the unrelenting backdrop of inhumane conditions which fail to reduce recidivism or properly rehabilitate incarcerated individuals. This must be addressed now. The implementation of an independent correctional ombudsman to oversee and investigate longstanding systemic problems within Maryland's correctional system is long overdue. Senate Bill 134 is an important first step on the road to eliminating the underlying causes of widespread dysfunction and prison corruption that has undermined rehabilitative efforts for incarcerated individuals throughout the state. This is a crucial and an extremely important function for several reasons. The ombudsman will serve as an independent authority to protect the human rights of incarcerated individuals. They will have the ability to investigate complaints and human rights violations within the institution. Secondly, they will work to prevent abuses and misconducts by providing a mechanism for incarcerated persons to report incidents of abuse and misconduct. They will work to hopefully prevent these events from occurring in the first place. This does not only contribute to a safer and more humane prison environment for the incarcerated persons, but all those who work beyond the walls. Ombudsmen also work to resolve conflict and promote better communication and understanding within the prison system. They work to improve prison conditions through independent investigations, monitoring and identifying issues, advocating for change, and contributing to the overall improvement of the system. Additionally, and equally important, that they promote the transparency and accountability of those who work within the prison system. They will have the ability to conduct impartial investigations and report on these findings to ensure that the actions of prison staff and authorities are subject to overall oversight. Ombudsmen play a vital role in upholding the rights of prisoners, and they promote a safe and humane prison environment. This is extremely important. And in closing, I do note that the Office of the Public Defender does support the amendment as presented by Attorney General Brown to establish an independent office to provide oversight. For these reasons, I ask the Office of the Public Defender strongly supports, and we ask that you return a favorable report. Thank you.
Chairman, Vice Chair, members, my name is Terry Schuster. I'm the Corrections Ombudsman in New Jersey. And I'm here sort of to say, ask me anything. So ask me anything. I will be here. I'll give you just a quick kind of intro. I have a staff of 20. I have a budget of about $2.5 million. We are located for administrative purposes. We're in the Treasury Department, but I don't answer to the treasurer. I answer to the governor. So if I need HR support, I get that from Treasury. If I need procurement, I get that from Treasury. If I need furniture or IT, I get that from Treasury. And so that's just a way, if you're going to create a new office, to not have to create all of those other things with it. Just, we put it into some part of government that can provide those things. We provide a call center. So there's hotlines. Anybody from prison can pick up a phone and call us confidentially. Any family member can call us or community member can call us. We get about 700 to 800 contacts per month. So some of my staff, some of the reasons why we have 20 staff members is just so we can run that call center because the phone's ringing all the time.
what I think the best thing that we have is enough staff to physically be on site in the prisons every week. And so I've got, there's 9 prisons in the state of New Jersey. We have staff who are on the ground in the facility, touring and talking to people and connecting with the administrators and troubleshooting issues at the lowest level possible, 2 to 3 days each week in each facility. And when they're not in the facility, they're back in the office answering the phones. We do inspections unannounced. And so we'll go show up and do an inspection either generally about living conditions, or we'll pick a topic. And so we did an inspection recently at 4 facilities where we were, I'm out of time, where we were looking at access to loved ones via phone calls and visitation. And so we did a survey with the incarcerated population. We sat down and did interviews, and we observed visitation and wrote up a report. We also do systemic monitoring. So we have we collect data and do system-wide monitoring of healthcare services and things like that.
Excellent. Thank you. I'm sure you'll get some questions.
Yep.
Good afternoon, Chairman Smith and members of the committee. My name is Olinda Moyd. I stand before you today in several capacities: as a volunteer with the Maryland Alliance for Justice Reform, as a clinic professor, and as a longtime institutional volunteer. In each of these capacities, I come in contact with people who live, work, visit, and volunteer in our facilities. The message is clear. Independent oversight is needed. Transparency and accountability are essential to efficient operation of government, but especially for those systems that are hidden away from public view. Now is the time to shine a light on what happens to men and women behind bars. We need to make these environments healthy and safe places for those who live there, work there, and visit. I stood before you last year, February the 8th, and made the same appeal. Since then, the problems in our institutions have not disappeared. The Maryland Alliance has collected letters from many of the men and women who have repeatedly asked for meaningful oversight. I hope that you will take the time to read each one that was submitted. We did submit 62 letters. The grievance process, they say, is long, it's lengthy, it's time-consuming and exhausting. One of the individuals whose letter you will read, gentleman at JCI, he writes in his letter, 3 major aspects of prison life, medical, dietary, and commissary, have all been privatized with very little oversight. The problem with the healthcare providers in the institutions is widely known. We receive letters from men and women who talk about their healthcare issues. Today, we were hoping that you would hear from individuals who have served time behind bars, their family members, and even DOC, former employees. But we have so many folks here today who support this bill. We ask that you hear us through our written testimony, and I'm asking everybody who's here in support of the bill to stand in solidarity. Thank you.
Excellent. Thank you very much. Always good to see you.
You too.
All right, we're gonna turn to the committee for questions. Senator West is up first.
Thank you, Mr. President. Mr. Chair. We're elevating him constantly. So a year ago, we had a bill from the Attorney General to give the Attorney General the power to not only investigate police officers, but also indict them and then prosecute them. And I remember expressing at the time a concern that coupling the investigatory function and the prosecutorial function in the same office was a bad idea. I'm so pleased that in this case, you believe that it is a bad idea. And so therefore you want the ombudsman unit, which will investigate these situations, to be separate from your office as Attorney General, which would prosecute them. Congratulations. But that does raise another issue, which we didn't have last year, which is who controls the ombudsman? And I don't have the amendments before me. So whoever has the amendments, it'd be great if you could stand at the podium and explain what happens if the ombudsman deviates from the straight and narrow. Who will have oversight responsibility over the office of the ombudsman?
Okay.
I'll take that one. And before I do, let me just say, for the record, last year, I did recognize the conflict in the pattern of practice and worked with the committee to deconflict that. In pattern of practice, you wouldn't see nearly the volume that you do in what I think you'll see in the correctional ombudsman and what the testimony that we heard. So as amended, the instead of the Attorney General appointing the correctional ombuds, it'll be the governor. So it'll be a gubernatorial appointment, and like, you know, most every gubernatorial appointment, they serve for a term and can be removed for cause. So they're accountable in that regard, but you want them to be truly independent. So they're not, you know, relieved of their duties simply because they are, you know, making certain findings in investigations or including certain content in their report that may not be popular. So the short answer is gubernatorial appointment and removal for cause.
Okay, and I assume that the amendments contain some constraints on the operations of the ombudsman, to hold them within the straight and narrow.
The amendments,
Again, I haven't seen the amendments.
yeah,
so-
the amendments do not change the base bill in that regard.
Okay,
I just want to follow up with one thing. It's also advising consent. So we have,
the
That
Senate will have
process.
to confirm.
correct,
Okay,
as
I-
we added last year when it came out of the
Yeah.
Senate in a different format.
well, that makes a lot of sense. I'll take a look at the amendments, but I think we ought to make sure that the ombudsman, once appointed, doesn't have carte blanche to do whatever the ombudsman wants to do without any kind of oversight. And we'll check the amendments to make sure that's not the case. Thanks.
Thank you very much and good afternoon. This question is for Professor Moyd. And if you wouldn't mind just coming to the podium, thank you. Could you explain why the Maryland Commission on Correctional Standards isn't sufficient to accomplish the goals of accountability and transparency?
I'm glad you asked that question. It gives me a chance to talk further about what's happening now. So there are several audits that are currently done over our correctional system. One of them are audits that are done by the Maryland Commission on Correctional Standards. One thing that's different from this bill, as opposed to what they do, is the ombudsman would have the authority to do unannounced visits, which is really key because we know what happens when you know company is coming, right? You dress up the place and you make it look nice. The Maryland Commission on Correctional Standards, their published guidelines requires that they give 60 days notice to the facilities before they go. It also requires that if the facility says we're not ready for you to come, that they do not go to those facilities. So that's one thing I'd like to point out. Another thing I'd like to point out about that commission, the last report that's published to the public is their 2022 report. Most of the audits that they do are really site inspections. They go through the facilities, they look at the lights, they look at what's working, they look at the equipment. And at one of the facilities, and it just happens to be the one facility that we receive the most letters from, JCI. And I'm just going to read one part of this. They went through the kitchen and it says, in the dietary area, the refrigerators were out of order, lights needed replacement in the ODR, the officer's dining room, and repairs for hot water were needed. That's what it says in their audit report. Well, guess what? That facility received a 100% rating at the end of the audit. So we need to make sure that we have an independent audit so we do have a true picture of what's happening.
Thank you very much.
And I encourage you to go to the DPSCS website and look at the Maryland Commission's reports. Thank you.
Thank you.
My question is for the sponsor. Thank you for bringing this bill. It's an important bill. No one knows this better than Senator McKay, but these are correctional jobs are very hard to recruit for. And we're down so many members, and you've done a great job, and the union has done a great job. The governor has been doing a great job trying to recruit into these positions. I don't want to accidentally make this a harder position to hire for. So I guess my question is, when there are baseless and unsubstantiated allegations made to the ombudsman, whether that's publicly accessible by our press, by the public, by members of the legislature. I'm just curious how those allegations are handled when they are unfounded.
I don't mean to punt this, Mr. Vice Chairman, but we do have an ombudsman who has experience with those very issues. And if I could,
About what happens in another state as to what's in the bill, although I am curious as to how that's handled in New Jersey. I first would like to know how that's handled in the legislation.
in the legislation, I think it would be up to the office to determine the merit of the complaint. And they would develop, is that right?
Yes.
They would develop guidelines to determine what was meritorious and what wasn't.
No, absolutely. And if it was unmeritorious, in other words, if there was no basis whatsoever for the allegation, would the allegation still be public information when that person went to be promoted? Or could the press MPIA that allegation? Or could we have knowledge of an allegation where that allegation was found to be unmeritorious by the office itself?
So if I may, that raises the issue of the Public Information Act. There are a host of exceptions. There are categories where you cannot disclose, categories where you have discretion to disclose, and categories where you must disclose. While I can certainly confirm with my PIA experts, I'm 99.999% sure that a complaint filed with the ombudsman that was found to be frivolous, trivial, vexatious, or not made in good faith, which means they would not investigate it, that would not be disclosed under the Public Information Act. That would be an investigation, and those are protected from public disclosure.
Talk about whether to clarify that in.
Absolutely.
It may turn on whether it's like, are the correctional officers to fall under that definition of law enforcement officers for, the purposes of Anton's Law the past couple of years ago. Further questions from the committee? I listening to this, we've kind of gone between this and the Juvenile Justice Monitoring Unit. And the Juvenile Justice Monitoring Unit has the ability to kind of make unannounced visits, but does not have subpoena power. This version of the bill has subpoena power and unannounced visits and a couple of other tools in the toolbox, which I think is great. And I understand the position that giving, like, let's say, since JJMU, the Juvenile Justice Monitoring Unit, is under the Office of the Attorney General, if you gave that office subpoena power, I understand that position that it puts the Attorney General in. So I'm wondering aloud, I would love to see the JJMU actually plussed up and beefed up a little bit as well. I mean, I think you can do these things in parallel. I'm wondering aloud, just if it makes sense. I mean, there's something going. You give me an idea. This independent department. You see where I'm going with this?
Yep.
Okay. Just putting it out there. I wonder aloud if you were interested in doing that, giving that office with some more tools, and then if we're going to create this independent entity. I'm just thinking aloud.
So I'd be happy to continue that discussion with you, Mr. Chairman. I also have been thinking about where else this could live, and I have a couple of other ideas. Be happy to talk about with committee.
And just also help. Obviously, we need to work in close coordination with budget and tax.
We do.
The challenges here are probably not logistical or political, but fiscal.
So the first year is just over $500,000,
Yeah, I
and it
saw
goes up to 8 something. I do think, obviously, if it were an independent unit, that would be slightly higher, but I think not insurmountable. And we have identified a potential funding source that I'd be happy to talk about with you offline.
It's not the opioid fund, is it?
No, it is
Okay. It's like,
It is
everyone's
not.
coming after that pot of money right now. Okay. All
It
right.
is not.
Okay, great.
If I could just make one point
Sure.
regarding your comment
Sure.
about the subpoena power.
Yeah.
Especially for those agencies that the government contracts out primary services.
Yeah.
We believe that having that subpoena power is critical, right? Because we can ask for records from the department, but when we talk about from Corizon and other contract agencies, having that subpoena power is critical.
I agree with you. That's great. Okay. Further questions from the committee? All right. Thank you all very much. Thank you.
Thank you.
We're now going to turn over to the next panel. And can we actually, is that?
I don't see the meeting.
We just, for the record, we have one person sign up in opposition here to testify virtually. but they're not in the Zoom room. Okay. Say what? Oh, I know. Oh, so don't conjure him up, he'll show up, man. All right. All right, so with that, that'll conclude the testimony in the hearing for Senate Bill 134. We'll now move on to Senate Bill 128 with Senator Heddleman. Welcome back.
Good afternoon, committee. My name is Shelley Heddleman. For the record, I'm here to present Senate Bill 128, which would make substantial reforms to our geriatric and medical parole system. Like the prior bill, this is a bill that the committee is familiar with. I also want to say from the outset that this is a bill that we've worked on for a number of years and have negotiated tirelessly with the Department of Corrections, with the Parole Commission. And I am going to share with you, unfortunately, he couldn't be with us today, but the head of the Parole Commission, Mr. David Blumberg, has, the chairman, presented a letter to the committee. It didn't get in on time for the deadline, but you all should have it. We presented it, and there are some parts of it that are key that I want to emphasize in my testimony before you today. Our law right now, as it stands, provides both for medical and geriatric parole release opportunities. And the problem is that the requests are rarely granted. And that is because our system is broken. And we have the chairman of the Parole Commission that attests to the brokenness of the system. And when you have the Department of Corrections and the Parole Commission, which is charged with making these really, really difficult decisions, asserting that the system is broken, there's something that we really need to take pause and respond to here. So, as this committee is well aware, over the past few decades, our prison population has grown, and that is attributable more to longer sentences than it is to increased crime. And as the community ages, just like it does outside the walls, we're all getting older, the care of older adults will cost more. As it currently stands, the department estimates that the annual cost of an inmate is over $46,000 a year. And estimates are that healthcare costs double for those who are over age 60. Current law enables anyone to apply for medical parole, except those sentenced for a sex offense and those ineligible for parole. No medical examination is required, and there is no hearing. A physician reviews the medical record, just a file, assigns what's called a Karnofsky score, something that wasn't intended to be used in this way and is not evidence-based, that measures impairment, and then sends a recommendation to the Parole Commission. The regulations are actually stricter than statute and stipulate that a person must be imminently terminal to be eligible for medical parole, which is actually more restrictive than federal standards of care. Under this bill, it would permit the incarcerated person, a family member, or other representative to request a meeting with the Parole Commission to request medical parole. They may also request a medical evaluation that the Parole Commission must consider along with other factors in assessing whether to grant parole. And that's actually meeting with a physician. This bill strikes a really important balance between the healthcare needs of the incarcerated person and public safety concerns by taking into consideration whether an ill inmate is likely to recidivate. With regard to geriatric parole, Maryland's experience with the younger population is telling. These are older inmates whose average age was 64 years old and had served an average number of 40 years behind bars. They were released back in, I believe it was 2013, 2012, and they have demonstrated that as individuals age, the risk to public safety is minimal. In other words, most people age out of crime. Senate Bill 128 also fixes a quirk in the current law that allows geriatric parole only for offenders who've committed multiple violent offenses and are not otherwise eligible for parole. This should be fixed. And then there are a couple of other technical fixes. I want to read a little bit from Chairman Blumberg's letter because I think it's really important. His commission is charged with determining on a case-by-case basis whether inmates are suitable for release into the community under supervision of the Division of Parole and Probation. As part of that responsibility, they consider a number of factors, including the nature and circumstances of the underlying offense, an individual's conduct while incarcerated, and any evidence of rehabilitation, and whether the individual has a realistic reentry plan and support. This bill does not lessen our obligation to consider those same factors when someone is reviewed for medical parole, but it does give the commission more specific guidance regarding the types of cases that are appropriate for consideration under the medical parole criteria. The current construction of the geriatric parole statute has allowed us to consider very few candidates. He estimates only 11 individuals meet the criteria for geriatric parole under the current statute, despite the population of age 60, totaling over 1,000 people. That's 11 people out of 1,000 people that would meet the criteria under our current construct. To the extent that the General Assembly intended to create a scheme for the commission to consider elderly inmates for parole in light of their age, we are unable to carry out that duty effectively under the current law. I want to repeat that. They are unable to carry out that duty effectively under the current law. The proposed legislation allows for review of those age 60 and over every 2 years. He says the commission is prepared to carry out the responsibility. And he says this, the legislation does not call for it, but this, again, the chairman of the parole commission would support a further reduction of eligibility to age 55. We are not calling for that in this bill. We are being consistent with what we did in 2016 when we changed consideration under the Justice Reinvestment Act to age 60. As with the medical parole provisions, nothing in the legislation will compromise the commission's ability to put public safety at the forefront of our decisions. Senate Bill 128 does not create any new avenues for parole consideration, but it does significantly strengthen and clarify existing law. I want to turn it over to my panel. And again, we are limited because this is a bill that you've heard before. I am happy to address, so far, there are concerns addressed by the state's attorney's office. Some of them are supportive of this bill. So I want to give recognition to those who are supportive. And I'm happy to, there are probably going to be issues or some questions raised about medical parole. And I think we have done a good job in this bill about recognizing what a terminal illness is, recognizing an inability to do one or more acts of daily living as going to the definition of what it means to have to be that ill to be considered for release. So I'm going to turn it over to my panelists and thank you for your consideration.
Good afternoon. My name is Willie Hamilton, and I'm a former incarcerated person who served 30 years, 110 days. And the reason why I'm in support of Senate Bill 128 is because I've been in these institutions where these guys who are in need of this compassionate release dwell in. These are environments that are not designed to house people who are critically ill. One of my duties was a wheelchair pusher. I was in charge of going to these buildings to get guys who are not able to walk to go to their medical appointments, to visits, or anything that required them to leave out of their housing unit. And what you see in these units is a horrible state. They are in need of things that we cannot provide for them. The institutions can't provide for them. If you would go to their cell, there's no one cleaning up their cells for them. They're unable to go to the bathroom, it is left in their cell. They're unable to go to the shower. These are issues. There's no one responsible for helping them to do this. Only those who are incarcerated people who may have some compassion for them may come to their cells and clean it up for them. We're not qualified. We're not getting paid for it. This is why there's a need for this bill. They are not in need. They are not what you can consider a person who recidivize. They're not a person who will be a danger to society. This is one of the reasons why I'm in support of Senate Bill 128. The atrocities that go on with these men and women who are in need of this. If you have any questions, I'm here.
Thank you. We'll take questions after the
Okay.
hand. Professor?
Good afternoon. My name is Lila Meadows, and for several years, I've had the privilege of representing incarcerated individuals who are seeking medical parole in the state of Maryland. So I've had a front row seat into the many ways that Senator Heddleman highlighted our statute currently fails people who are in really bad condition behind the wall. And I can take questions about the types of clients I've represented and what that process has looked like before the Maryland Parole Commission. But what I really want to highlight is that this bill, as the chairman noted, gives greater direction by creating legal definitions of what constitutes a terminal illness, but also what constitutes being chronically debilitated or incapacitated. And that's really, really important because it's important to understand that members of the Maryland Parole Commission, they're not medical professionals. They're not trained to look at these records and know what it all means. And the current system we have, basically, commissioners, unless there's something on a piece of paper where a doctor is saying you're dying in 2 weeks, they're not granting in these cases. Before I went on maternity leave in November, the last thing I did was submit a medical parole request for a gentleman in a correctional institution with a chronic degenerative neurological condition that is causing him to sort of lose fine motor skills and lose control of his bowel movements. I had documentation from medical professionals in the facility that said he is currently unsafe in the correctional environment because he can't physically navigate it and because he is defecating all over himself, and other people on the housing unit are angry. I gave birth to my daughter, and 5 days later, I got an email saying that he was denied medical parole. No explanation was given. I looked into it, and it was because the statute is being interpreted as requiring a terminal illness. He's not a threat to public safety. He can't dress himself. He can't bathe himself. What we have here is an inhumane system. It needs to be corrected, and I urge a favorable report. Thank you.
Thank you very much. Questions from the committee? All right. Well, thank you all very much. I definitely we'll be in touch to work on this, but thank you all for your testimony. Thank you. All right. We have two witnesses joining us favorable with amendments, and one is virtual. So we're going to go with is Kristen Hill here? Virtual. Virtual. Let's do that real quick, and then we'll do the last in person. All right, Ms. Hill, you are up and ready to go. Welcome.
Hello. I just want to thank you, Chair, and all of the committee for giving me the opportunity to speak today. My name is Kristen Burr-Hill, and I'm a domestic violence advocate. I'm in support of this bill. However, I'd like to encourage you to add a domestic violence exception. I won't go too far into the statistics today, but there are more in my written testimony. But we know that domestic abuse is an epidemic that disproportionately affects Black women. This bill isn't just a medical parole bill, but a geriatric parole bill as well. And I support this bill because we know recidivism drops with age. However, none of those studies have isolated domestic violence. And domestic violence is incredibly different from other violent crimes, both in motive and opportunity. So we'd be remiss to treat it identically for this purpose. My best friend, Lauren Charles, a Silver Spring resident, was brutally murdered by her husband. He's a prime example of this bill's shortcomings. He was 45 at the time of conviction. At the age of 60, he will have served 15 years and would be eligible for a parole hearing every 2 years. The factors the Parole Commission is told to consider under this bill may incorrectly indicate that he is primed for release. Things such as criminal and prison records, moral qualifications, and studies on recidivism do not account for the nuances of domestic abuse. Other parole factors related to the victim put the onus and risk on the survivors. This bill expects the Parole Commission to be experts on domestic abuse. In my example, Lauren's killer could be released, get on a dating app, and quickly be in another situation to hurt a woman. And unfortunately, Lauren's story isn't unique. Many abusers go home to their original victims. As the bill is written, there is an exception for registered sex offenders. I'm asking that you add another exception for domestic abusers. I believe that we should have a greater interest in keeping people safe in their own homes. As I said, I support this bill, but I'm not in support of it at the cost of people's lives, particularly the lives of Black women. Thank you.
All right, thank you very much, Ms. Hill. All right, we'll hear from our last witness who's in person is Ms. Lipscomb.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, and members of the committee. My name is Lauren Lipscomb, and I'm the Chief of the Conviction Integrity Unit in the Baltimore City State's Attorney's Office, in which I've been a prosecutor for just short of 20 years. I'm here today to provide testimony on behalf of my office, as well as State's Attorney Bates and the Maryland State's Attorneys Association. I'm here to address the medical parole portion of the bill today only. During my tenure, I've handled in one form or another the prosecution of thousands of criminal cases. In the criminal justice world, the nature of the convicted offense matters, as we just heard with domestic violence cases in particular, in assessing threats to the safety of our community. Violent cases are appropriately subject to higher scrutiny when being considered for an early release. The universe of cases that this bill seeks to address will mostly involve violent offenders. Senate Bill 128 permits any offender, violent or not, the opportunity to be released on medical parole, whether or not physically incapable of committing further violence, which is at the center of our concern. I have personally prosecuted 2 offenders who were released on medical parole and went on to commit violent offenses, beating a man over the head with a stool and a sex abuse of a minor. We agree that there are cases in which medical parole is appropriate. However, the bill needs to be amended to ensure consideration of physical incapability, especially given the medical conditions captured here are vast. To accomplish this, our position remains the same as it was last year. We support with an amendment to page 3, line 27, by deleting the word or and adding the word and. Thank you for permitting my testimony today.
All right, thank you very much. Questions from the committee? Seeing none, thank you. With that, that'll conclude the hearing for Senate Bill 128. We'll now move on to Senator Carter. Good to go? Okay, Senator Carter with Senate Bill 132. Senator Carter, would you like to bring up your panel?
Yes, I believe my panel of 2 people, because this is a bill that's been heard before, unfortunately. So if you're here in support of Senate Bill 132.
The other is, I think she's joining us virtually.
Okay.
Elise.
So Mr. Chair and committee, you're going to be really happy with my presentation. It's going to be so succinct, probably the most succinct today. We've heard this bill before. We just listened to a bill that dealt with the issue of medical parole. My bill is simply to fix a technical error. When we passed a law a couple of sessions ago to finally, after decades and decades, remove the governor from parole decisions for inmates that are deemed, I guess, healthy because they're not seeking medical parole, we neglected to include medical parolees, people that are eligible for medical parole. This bill does nothing to change the factors for determining whether someone's eligible for medical parole. It simply says that for these really sick people that are deemed to be so chronically ill, according to the statute, language of the statute, that they are not a threat to the public safety, that they would also have the benefit of having the governor out of parole. This is not an ideological issue for you. If you don't believe that the governor should be taken out of parole, this isn't the issue, because the governor already is out of parole. But for healthy people, we want the governor out of parole for these really sick people too. And so that's my testimony. This should really be a no-brainer. We just heard about how difficult it is for some people to even get released on medical parole with the parole commission. So this really shouldn't be a thing. This bill should sail out of this body, and we should be done with this issue forever and let these sick people get the same opportunities as we do for everyone else. Thank you.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, members of the committee. For the record, my name is Yanetta Emanuel, Public Policy Director for the ACLU of Maryland, here in support of SB 132. First, I'd like to thank this committee for passing this bill out last session. And as a reminder, this bill is just a technical fix. In 2021, the General Assembly voted to remove the governor from parole for people serving life sentences. And it was clearly the legislators' intent to establish that the Maryland Parole Commission would be the final decision maker for all parole decisions for Marylanders sentenced to life imprisonment. However, the section of the code pertaining to medical parole was mistakenly omitted from the bill draft, resulting in a situation where only medical parole decisions require unilateral action. As a result of this error, medical parole decisions made by the Parole Commission remain subject to a waiting period of 6 months, which is dangerous and unfair for Marylanders who need medical parole. SB 132 would simply correct this omission. The need for the Parole Commission to be able to act expeditiously is arguably the most critical in those cases where the parole candidate is seriously ill or dying. The 180-day waiting period alone may be the difference between a peaceful death surrounded by family or a lonely death inside prison walls. Indeed, in 2021, five people recommended for medical parole died waiting for the governor to act. Medical parole is only awarded under extremely strict criteria. Under COMAR, only individuals who are chronically debilitated or incapacitated by a mental health condition, disease, or syndrome, and are physically incapable of presenting a danger to society may be released on medical parole. SB 132 would ensure that the terminal illness does not bar someone from a fair and expeditious consideration of their request for release. For the foregoing reasons, the ACLU of Maryland urges a favorable report on SB 132. Thank you.
All right, we have one witness joining us virtually. Ms. Desiderio, welcome.
Hi, good afternoon, all. I'm Elisa Zadario, an attorney with the Appellate Division of the Office of the Public Defender, also urging a favorable report on Senate Bill 132. Again, the only thing this bill does is strike the lines of text in what is now subsection 7309I 1 through 3. And I just want to read that section out and walk through it so that we know what we're looking to excise here. That section is: if the commission decides to grant medical parole to an inmate sentenced to life imprisonment, the decision shall be transmitted to the governor. The governor may disapprove the decision by written transmittal back to the commission. If the governor doesn't disapprove the decision within 180 days after receipt of the written transmittal, then and only then does the decision become effective. So that's what we're talking about when we're talking about a 6-month waiting period, because we have to wait that 6 months to make sure the governor will not say no. We need this language excised because, as we've heard, people seeking medical parole often have very rapidly deteriorating and fatal medical conditions. We need the Parole Commission to be able to act promptly in these cases. This bill allows for that. The Parole Commission is able now to act independently in all other cases of parole for lifers. We are just trying to make that equitable for sick people as well as the healthy. So we urge a favorable report. Thank you.
Thank you very much. Questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 132. We'll move on to Senator Carter with Senate Bill 71.
Thank you, Mr. Chair and committee. If anyone is here in support of Senate Bill 71, please feel free to approach the front table, witness table.
Hey, we got Lisa, is it Lisa Spencer and then Debbie Jensen?
Oh, that's right. I only get two people. Well, as you can see, Mr. Chair and members of the committee, if you look at the favorable testimony,
Yeah.
so many different organizations and groups that are in favor of not only maternal health, but also bonding, know the efficacy of allowing bonding of mothers and children when they're first born, babies when they're first born, have signed up in support, including Planned Parenthood and a myriad of others. So I'll be brief as well on this because we heard this bill before. And, you know, earlier this session, I presented to this committee the idea that we could not allow the claim of administrative burden or cost to interfere with what we know is right in our hearts and in our minds. There's been a plethora of evidence that it is in the best interest of both the mental health of mothers and children to have a bonding period. Right now, literally a mother that is incarcerated could give birth to a baby and have that baby immediately ripped from her and put into the system of social services, foster care, or some other kind of government oversight. All this bill does is require that Department of Corrections would basically allow for a woman that is pregnant to have the benefit of accommodations at our pre-release center once built. I'm happy to say that you all know that in this governor's budget, there's 4 million allocated towards, so we're making progress. We of course would not expect the department to do anything prior to it being built because it's not possible. So we're not asking them to do anything that's not humanly possible. We're asking them to accommodate a common sense accommodation once it's available. It's my understanding too that I saw the letter of information from the department. And it talked about, oh, this could allow liberal visitation from fathers with babies and the like. You know, there's a myriad of different scenarios that one could conjure up to think, oh, this terrible thing could happen or this could be a problem. I think all we're saying is that we should make it law and policy that there is a period of at least a year for a woman that gives birth to a child that's incarcerated to have that bonding period, and that we need to make those accommodations. If, of course, there is a problem with visitation from the father, then that's something that can be decided or limited or restricted by the department or by the facility. Anybody here that's an attorney, you already know that when we have clients in these facilities, we ostensibly have liberal 24/7 visitation, right? But we know that they do restrict us sometimes. They could have a lockdown or a myriad of other things. They say, sorry, attorney, you can't come now. So it's kind of like illogical and nonsensical for any claim to be like, well, this could cause people to visit. No, the facility still has 100% control over who gets to visit. So my argument to this committee is this isn't about just the mother and the mother's mental health. And maybe some of us just want someone that did something terrible to be punished forever. This current law, or the lack of having this law in place, punishes the child. It impacts the development of the child. It impacts the mental health of the child. Children that are products of incarcerated parents, according to research and data, are 3 times more likely to have behavioral problems. And so this is a public safety bill because this bonding period is shown to actually benefit the cognitive, the behavior, the mental health of the child. Finally, it's not just about the mother and the child. It's about who we are as a state. It's about whether or not we believe in the humanity of all people, whether they are incarcerated or not, and whether or not we want to have the best outcomes for children and families of incarcerated individuals. Thank you.
Good afternoon. My name is Lisa Spencer. I'm a certified nurse midwife. I'm a certified nurse midwife, a women's health nurse practitioner. I'm a clinician who has worked in the juvenile services as a midwife, and I'm here on behalf of the Maryland affiliate of the American College of Nurse Midwives. And rather than using 2 minutes to try and summarize the entire body of evidence that shows, forced separation increases for the gestational parent, depression, anxiety, suicide, drug relapse, overdose, long-term behavioral obstacles, as well as interrupted lactation, which has its own long-term problems for both the parent and for the child. Instead of using 2 minutes to summarize that, because medicine really loves to create studies that prove the obvious, which is that it's a problem to separate babies from their gestational parents, I'm going to ask that, you know, I've delivered nearly 1,000 babies into this world, and I can't really summarize what it's like in that moment afterwards, to see a patient lose their baby, have that baby removed from their room. I can't describe the sobs. I can't describe what it's like trying to treat those patients. But, you know, if those very mediocre dad jokes are an indication, some of you here are parents, and many of you probably have the experience in the wee hours of the morning of finally getting your little human to quiet as they are nestled in your arms, on your chest, and the experience of rapid oscillation of anxiety and fear and pure bliss, and what it would mean if you didn't have those experiences as a parent, what it would mean if you didn't have that experience as a human, and what it would mean to that baby.
Well, that was a charitable description of the jokes, but thank you for the testimony. Senator Walstreicher.
Thank you, Mr. Chairman. Senator Sidnor had to step out to testify in another hearing, but he wanted to document for the record the numbers here. So how many women give birth in the penal system in our prison system, state prison system each year, Senator Carter?
So it would take me a moment to look through this information to find if there's an exact number. But let me just tell you that over the interim, Delegate Marie Q. North and I met multiple times, she more than I, with the with representatives from the department. And what I recall is the number is not many. It's a very small number. There aren't that many women that are incarcerated who are pregnant and ready for pre-release. It's more often the case that someone might come in pregnant, but they wouldn't be ready for pre-release as often as someone that had already, you know, so it's not that many. And as you can see, there's no real opposition, I don't think. There's just a letter of information. It might have it in there. I don't have the letter of information with me up here though, but it's in, I saw it in the testimony. Is that good?
I'll get the number.
I'll find the number.
Yeah.
I mean, it's not, when I say not many, like it's really a small number. It's like less than 20, you know?
Yeah, thank you. All right, further questions from the committee? Seeing none, thank you very much, Senator Carter.
Thank you.
Thanks. All right, so with that, that'll conclude the bill hearing for Senate Bill 71. We'll now move on to Senator McKay with Senate Bill 402.
Mr. Chairman, for the record, Senator Mike McKay presenting Senate Bill 402 Correctional Training Commission Membership Alteration. On January 18th, 2023, Governor Moore stated, going forward, Moore promised, Maryland will leave no one behind. I believe this bill ensures that the Correctional Training Commission membership will leave no one behind, as it has a true balance of geographical regions. So at the end of the day, this bill just does a couple different things. The members of the commission that are appointed by the governor will represent the 5 different geographical regions. Regions will be called Capital, Central, Eastern Shore, Southern, and Western, and it will accurately represent each of the regions and counties as the commission goes forward. I ask for a timely, favorable report, and just like me, short and sweet.
Questions from the committee? I think we have one person. Okay, so just for the record, Ryan Ross had signed up to testify in favor of the bill from the Maryland Correctional Administrators Association. Seeing no questions from the committee, thank you very much, Senator.
Thank you.
All right, with that, that'll end the bill hearing for Senate Bill 402. We'll now hear from Senator Benson, who I think just joined us. Welcome, Senator. Senate Bill 36, Senator Benson.
Good afternoon, Mr. Chairman, Mr. Vice Chair of Judicial Proceedings Committee. I'm here to request your consideration for Senate Bill 36, the Maryland Death in Custody Oversight Board. More and more, we are hearing about the need for oversight and transparency within our law enforcement agencies. This bill is designed for these purposes. It is requiring law enforcement and correctional agencies to publicly report specific information on in-custody deaths. Each agency must report to an appointed oversight board or special inspector, which will be chosen by correctional ombudsman. The information regarding the death of the inmate in custody must be released on their website within 10 days of the date of death. Senate Bill 36 is very comprehensive, but it is extremely important if we want to do our part in establishing trust between the public and our law enforcement agencies. We have solicited assistance from 15 advocates, law schools and clinics, students, and the community in compiling Senate Bill 36. It is our hope that you will give careful consideration to the contents and provide a favorable response. Thank you.
Excellent. Thank you very much, Senator. We'll seeing no questions from the committee, we'll move on with some of your panelists, if that's okay with you. Excellent. Thank you, Senator.
Thank you.
Can we hear from Olinda Moyd? Welcome back. Lakia Polk, William Haynes, and Jade Eaton. Welcome.
Good afternoon again. Mass incarceration coupled with extreme sentencing has created hopeless environments where people who enter when they are in crises or experiencing mental distress have an increased probability that they might die in detention, and those who are serving longer sentences are left to grow old and eventually die alone, sometimes in a cold prison cell. Sometimes this is due to subpar or negligible medical attention, but the humanity in each of us should mandate that the death of every person while in a local or state custody must be properly documented, examined, and thoroughly analyzed. This is especially true since African Americans are disproportionately represented in our incarceral system. I urge a favorable report for this bill that would require that every death of an incarcerated person, the oversight board would be required to conduct an administrative review and a clinical review within 30 days of death and report such findings. We believe that this bill complements the reporting requirements of the Ombudsman bill, which you've heard about earlier today. Also, for every death that is determined to be a suicide or the result of a mental health crisis, an independent review should be conducted. Correctional staff is untrained to diffuse mental health crisis situations, and a person who is suffering from an substance abuse, or detoxing or overdosing from drug abuse must receive proper treatment. If a death occurs, it must be properly documented. The death penalty in this state was abolished in 2013. Every death that happens in our institution needs to be properly reported, analyzed, and addressed. Thank you.
Good afternoon to the committee. My name is Micaiah Polk, and I'm a 20-year-old resident of Maryland, currently attending Stevenson University with majoring in criminal justice and legal studies. I am here today with Helping Ourselves to Transform under Dr. Carmen Johnson in full support of Bill 36. The correlation between high rates of poverty, large African-American populations, and in custody deaths is truly alarming. The presence of these factors appear to be strongly correlated with in custody deaths, indicating systematic issues that have sat unaddressed for far too long. The misclassification of deaths officially designated as natural raises serious concerns about the accuracy and transparency in reporting, especially in the instance of minorities. The discrepancy between the average age of in-custody deaths and life expectancy suggests a need for a thorough review of the classification process. The fact that over 80% of the deaths occurred while individuals were awaiting trial and nearly half within 10 days of admission underscores the urgency of addressing the risks associated with short stays in detention. The existence of high barriers preventing public access to crucial information hampers comprehensive study and inhibits accountability. Transparent reporting is essential for an informed decision-making and public awareness. Based on these findings, I join the call for immediate action to make the following recommendations that the bill addresses. In conclusion, it is imperative that you as policymakers take swift and decisive action to address the deeply concerning issues raised in the report. The human right crisis reflected in these findings demand a comprehensive and collaborative effort to reform our criminal justice system. Thank you.
Good afternoon. I'm Jade Eaton. I live in Greenbelt, Maryland. The study attached to my testimony shows that in the years 2008 to 2019, at least 180 people held in local city and county detention centers died in custody. These are the first places that people are taken when they're arrested, and tragically for some, the last places they'll ever see. And yet there's presently no systematic means to hold the facilities accountable to support the circumstances of those deaths. I'll repeat a few of the statistics that were just given. In this study, over 80% of the people who died were in pre-trial detention. They had not had a day in court. Over 1/6 died in the first 2 days of detention, and over half died in the first 10 days. And this is the information that we know. We also know that this is not all the information. What's clear is that there are substantial gaps in the reporting of deaths in Maryland correctional facilities. When CourtWatch tried to support more recent deaths in jails in Maryland, we found no central state reporting system or depository for circumstances of deaths of those who died in local facilities. We found no state office that collects this information. We sent each locality a public information request. We found no consistency in the information that they record on inmate deaths or how they record it or maintain it. Senate Bill 36 is a minimum first step to creating an accounting and accountability for the circumstances of deaths of all people who die incarcerated in Maryland. It is the least that the state can do to respect the humanity of a person who dies away from family and community, isolated in state custody. It ensures that there will be answers for the families of the deceased inmates and for you who are responsible for the laws that govern our criminal justice system. Being arrested shouldn't be a death sentence, and this oversight will help ensure that it isn't. I ask that you return a favorable report. Thank you.
Thank you for hearing me. My name is Bill Haynes. I'm a court watcher for Prince George's County. The jail there is a good argument for this bill, whether or not it's a typical jail. I've heard some things in bond review, but I'll give you something better attested. You've heard statistics from 2008 to 2019. In 2020, Weeks into the COVID lockdown, inmates sued the jail over medical care. The federal district court judge wrote in a formal opinion that the jail, in the person of the director, quote, exhibited a reckless disregard for provision of basic care, end quote. 7 weeks after the governor declared a catastrophic health emergency, only 18 inmates had tested positive, but only 20 had been tested. The jail had another 20 kits laid by, but no plan to get more. 9 weeks into the emergency, the court's expert inspected the jail for 2 days and wrote, quote, nurses lack a basic understanding of COVID-19 symptoms and their dereliction was patent, end quote. Sanitation was largely absent. Appointments were mostly denied. Those at high risk were not separated, and patient records strongly suggested to the expert that the medical unit lacked the equipment or skill to take accurate temperatures. A settlement agreement with the rules of care and inspection expired in December 2021 at the height of the jail's greatest outbreak. Since the settlement, jail staffing levels have fallen by more than a third. An oversight board would be a way for us to try to know if we're meeting our responsibilities and what remains undone. Thank you very much.
Thank you very much to the panel. We have a couple questions from the committee. Very good testimony, especially from Ms. Polk. Thank you for joining us. I hope you continue to stay engaged in this process. So look forward to seeing you and working with you in the future in Annapolis, but I hope you stay engaged. Senator McKay. I always love to see the young folks come up, it's good stuff.
Thank you, Mr. Chair. I think this, if I could talk to Ms. Moyd,
Yes.
if you want to come to the podium, that way we get to see each other. So, I want to talk about classification. You're talking about being misclassified. Can you expand a little bit more about like misclassified?
I'm not sure if I use that word, but I do think that, so as I indicated earlier, I've spent a lot of time volunteering in and out of Maryland's institutions. There have been times when I have received a phone call from a staff person, a caseworker, a nurse, who has said someone has died in our facility. Particularly, most recently, a person who passed away who was at the regional jail in Jessup. And the person called me because they were concerned that the death would not have been reported as a death that occurred in the institution, that because the person was taken out to the hospital, like immediately prior, that death would be classified as a death that occurred in the hospital as opposed to in the institution. And so those are the kinds of things that I see in my role. And, I'm not accusing anybody of fudging the numbers, but that death would then be counted as a death that occurred outside the institution and wouldn't be classified as a death that occurred while the person was in custody.
Right. So I guess suicide, how does that fall in? Is that something that should be reported by this group as they look at?
Yes.
To understand how many unfortunate deaths were by suicide?
Yes, one of the provisions of the bill is that for suicides that occur in the institutions, that there be and I will just read the provision, it's on page 4 of the bill. For every death of an incarcerated individual in the state that is determined to be a suicide or that has occurred in conjunction with a mental health crisis, that the board shall conduct an independent review. And we believe that that's important, of course, because the determination of whether it's a suicide or not is something that an independent person, we believe, would find.
So your testimony is stating that we would want to identify if it was a suicide or not. We wouldn't want like a death certificate to just not have any of that death. So
Absolutely.
so it's so important transparency wise that we actually understand, we know how the death happened.
Yes.
Would you say that that would extend to pretty much anything that the government does? We should know truth and transparency.
Well, that's why I think you hear us today calling for independent oversight.
Independent
and-
oversight.
And oversight that takes place outside of the agency.
And so
I
that-
believe that's, I said it before, when we talk about the efficient operation of governmental systems, we have to have transparency and accountability. It's important.
Okay, okay. Thank you very much. Senator Benson, thank you for bringing this bill. It's a good bill. Look forward to working to see it happen. And I think it's very important that the testimony talked about that government facilities need to make sure that we have transparency and understanding and classifying when thing is a suicide and when it's not. Thank you.
Thank you.
Thank you. And I apologize. I was out at another committee, so you may have covered this, but I was looking at the senators, the sponsors, her testimony, as well as that from the Office of Chief Medical Examiner, and I'm trying to understand. I'm assuming once they do the investigation, whatever, is it not true that if they do an investigation, this material isn't then made available to next of kin? And whoever knows the answer, please, because
Yes. I believe that the creators of the bill who are on the next panel will be able to.
okay,
definitely
I'll hold
answer
my
that.
question. Thank you.
All right, thank you very much. Thank you all. All right, next we'll hear from, is Miss Hilliard here? Hey, how are you? Elizabeth Hilliard, Terrence Keel. Laura Israni. And Lance Wines. Yes. Yeah.
Is it possible to have her on my?
Of course, yeah.
Sarah.
Sarah McKinley. Okay, yep, Sarah McKinley, you're on the page. Yep, come on up.
Okay, go ahead.
Ladies first.
You can grab another chair over there if you want. But just don't take Mr. Ford's chair. All right. All right, welcome.
Hello. Good afternoon. My name is Sarah McKinley, and I'm a student social work intern with the Office of the Public Defender in Baltimore City. According to data that was released by the Maryland Department of Public Safety and Correctional Services, approximately 885 people died while in state custody from January 2009 to March 2023. A recent report, which analyzed a sample of 180 self-reported deaths in 10 city and county jails in Maryland between 2008 and 2019, was estimated to be over 1,000. About half of those people died within the first 10 days of incarceration, and more than 1 in 6 died within 1 day. Over 80% who died in custody were awaiting trial. These findings suggest that any length of pretrial detention in Maryland could mean a potential death sentence for many individuals. The in-custody death crisis in Maryland presents major questions regarding basic constitutional protections for people awaiting trial. A system that confers potential death sentences onto people, many of whom have not been convicted of any crime at all. Some deaths during incarceration may be prevented by ensuring human rights-based approaches to management in correctional settings. This involves ensuring safe conditions, including reducing overcrowding, providing an environment and adequate facilities to services to protect the right to health, preventing torture and unlawful use of force or restraint, and maintaining effective governance and control of the facility to ensure safety for all. The collection and availability of accurate and up-to-date data on deaths in custody is crucial to identify any trend or factors that may be related to the most common causes of death in a given jail or corrections system. With the data collected, the Maryland Deaths in Custody Oversight Board can make findings and recommendations related. Oh my God. I'm sorry. Senate Bill 36 will guarantee that pertinent details regarding individual in custody deaths will be made accessible to public, providing greater transparency, insight, and accountability for in-custody deaths that occur on the state's watch. For these reasons, the Office of the Public Defender respectfully requests that the committee issue a favorable report on Senate Bill 36. Thank you for your time.
Future public defender, you got him in the pipeline early. I like it. Good stuff.
I'm used to saying, Your Honor, or ladies and gentlemen of the jury, but I will say, distinguished members of this assembly, my name is Lance Gunnar Wines. I am the Assistant Public Defender for Washington County, and I come to you today with the hope that not only do you consider this bill before you, but that you consider the man before you as well. I come to you as a citizen of Maryland, someone who is certainly familiar with the public opinion of our criminal justice system. This bill would ensure that we could transition away from our carceral system that many view as a system of injustice and transition into what we hope to be a reformative system of justice. We need to create public trust that we respect the dignity of this vulnerable population. We need to ensure that there are standards and conditions of confinement through any oversight. And we need to remember that this bill affects the public, not just those who are incarcerated. But I also come to you proudly as a public defender for the state of Maryland. And I know that I have to deal with not only our clients who are facing the potential incarceration, but also their families and friends. We need to be transparent with what the people that I represent will endure in their conditions of confinement. We need to humanize the very human prisoners and inmates that we meet, and we need to mitigate any trauma experienced by the family and friends of our incarcerated population. This bill would ensure that there's an appropriate and timely response to these crises, and we will allow for public transparency with the innocent victims of crimes, because we are all victims of something. And finally, I come to you as a son, the son of a beauty school dropout and a convict, the son of an inmate who died while incarcerated. I come to you as someone personally affected by this bill with the hopes that nobody on any side has to experience the horrors that I have experienced. So thank you, and please be favorable.
Good afternoon, Chair, Vice Chair, members of the committee. Lance and Sarah have really covered all of our information for the Office of the Public Defender. I'm here to field any questions and just urge you to read our written testimony as well as issue a favorable report on this bill. Thank you.
God bless you. No, Lance, that was Mr. Wines, that was very I think inspiring testimony. So thank you for sharing that.
I really appreciate that. Thank you, sir.
Thanks.
Good afternoon, Mr. Chairman, Vice Chairman, and members of the committee. My name is Terrence Keel, and I am a professor of human biology and society at the University of California, Los Angeles, and also the founding director of the Lab for Biocritical Studies, which was responsible for the report that was discussed by my fellow panelists. What we do is we use public health research, legal analysis, and data science to study in-custody death throughout the United States. As it was mentioned earlier, in August of 2023, my lab released a collaborative study with many local organizations that are represented here, looking at 180 cases of people who died inside of Maryland detention centers and jails throughout the county. I will note that while we looked at 180, there were in fact 1,000 cases which we could not entirely verify. The reason is that the quality of the data was not consistent enough for us to identify the names, the case numbers, date of death, and birth of these particular people. We did find, though, that the detention centers with the most instances of in-custody death tend to be located in places that had high rates of poverty and large Black populations. As has also been discussed earlier, half of the people in our study died within 10 days, as well as many of the cases, around 80% of the cases, were people who died in pretrial status. In the state of Maryland, access to information concerning in-custody death is hindered by the absence of uniform reporting mandates and data gathering practices. Access is also limited by the ability of law enforcement to delay, deny public disclosure of death investigation records. And this lack of transparency creates the opportunity for bias, undue influence from police and correctional institutions, as well as misclassification by medical examiners and coroners. From our analysis, Maryland ranks in the top 10 of states for reported in-custody death, but we believe that a great deal more cases would be revealed if the state provided clear directives for reporting and investigating in custody deaths during arrest while in the custody of law enforcement. Thank you.
Good afternoon. My name is Alora Thadani Azrani, and I'm an attorney at Civil Rights Court in Washington, D.C. Civil Rights Court litigates and wins civil rights lawsuits challenging unconstitutional practices in the criminal legal system around the country. I am currently fighting alongside hundreds of Marylanders locked behind bars in Prince George's County in violation of their constitutional rights. Through my work, I've seen how Maryland's default lack of transparency in jails conceals horrific dangers of incarceration. I'm here today to urge you to help shed light on the tragedies happening beyond public view in Maryland jails. The current lack of transparency around in-custody deaths is part of what makes jails so deadly. In 2021, I personally accompanied a medical doctor inspecting the Prince George's County Jail as part of a lawsuit about a lack of medical care in that jail. I personally saw people experiencing visible medical crises whose requests for doctors and nurses were ignored. I saw blood smeared on the walls and black mold on the ceilings. The doctor performing that inspection concluded that the medical care in the jail was grossly inefficient. Beyond those incarcerated, too few people see what I saw. It took a federal class action lawsuit to gain even a day of access to inspect that one jail. There are over 30 other jails and prisons in Maryland, and bringing costly, time-intensive lawsuits to inspect every one of them is not possible. This is why transparency must be the default. A recent Maryland report estimated that 85% of individuals who died in custody died awaiting trial. These people are presumed innocent. Incarcerated Marylanders, their family members, and state taxpayers deserve to know why their loved ones are dying in custody. I urge a favorable report of this bill. Thank you.
Thank you very much. I have two questions. One, and I think this is the appropriate panel. The question I asked earlier about the role of the chief medical examiner. Is this the right? Am I asking the wrong panel?
Sure, if you could just repeat your question, please.
Well, I was trying to figure out, I guess they're the ones who they come in and they'll do the investigation if there's an custody death. I guess whatever findings they have, I'm assuming that's made available to next of kin and the like currently?
Sure, of course. So I believe the question is, when a medical examiner coroner does an investigation of an in-custody death, are those records available to next of kin? Yes, they can be, unless those cases are put on a security hold for investigative purposes via law enforcement and correctional officers.
Got you. And the second question I have, on page 3, there's a new section 9-3805, where it kind of talks about this administrative review process about the quality of care and the like. I'm wondering, who does that now, or is that done?
No, I don't think I'm the right one to answer this question now.
Okay.
Thank you for your question, Senator. My understanding is that it is written in here because it is not already done.
Gotcha. Thank you.
All right. Seeing no further questions, thank you all very much. It's been great. All right, we'll move on to the next panel. We'll hear Ms. DeMarcus Moore, Tegan Murphy. And then the next two witnesses are going to be joining us virtually. Are you signed up? DeMarcus Moore and Tegan Murphy. What's your name? I'm sorry. Are you signed up in favor of this bill, or? Yes.
I'm one of the people that helped contribute to the report, so yes, and I also checked the box to be able to give my oral testimony. I'm not sure what's going on. And DeMarcus Moore is one of my interns and he's not here.
Okay, so maybe he signed up for you. So go ahead, come on up.
And I have another student, Nas Mathis.
Yes, Chambers,
Yes.
virtually, right?
Yes.
Yes.
He goes to St. Mary's.
Excellent. Yeah, we have him in the queue.
Okay.
Uh,
Do you want me?
Yes, please.
Okay.
Thank you.
Hello, everyone. Thank you for having me today. I am Dr. Carmen Johnson. I'm the founder of Helping Ourselves to Transform. I'm also the director of Court Watch Judicial Accountability that's powered by Life After Release. I'm a member of the research team that analyzed the in-custody deaths in Maryland and produced that amazing report with more horrifying details that are still coming in today. I dedicate my time to James Fowler, who has been wrongfully imprisoned for 30 years. For the record, James says, and I read, "My time in prison has been marked by witnesses of numerous violent deaths that has impacted my mental health. Baltimore Penitentiary, I saw fatal stabbings while guards and staff stood there watching. Jessup Penitentiary, a stabbing during a game, both under watch by guards, and the person laid in their blood for hours, dead. These experiences underline the emergency need for improved mental, medical, and correctional support in Maryland prisons, where the cycle of deaths disrupts and impacts our lives here and traumatizes and damages our state of mind. The lack of trauma counseling further destroys the prison population's mental state. It's clear an oversight board is needed to show transparency and address these unchecked deaths, prevent medical conditions, mental health needs. I strongly support," James says, "SB 036 from behind the wall for this reason." And I, Carmen Johnson, will state for the record, we're still getting in data and numbers. And like one of the public defenders said, right now we received information that 885 people have died from 2009 to 2022, from 2009 to 2022. So that means that we still don't have the numbers that go into 2023 and then to 2024. And so I urge you all to vote favorably for SB 36. Thank you.
Question. I didn't get the numbers that you said from
January 2009 to May 2022, it's 885 or 886 that have died. And that's like Professor Moyd said, that's not including the ones that have gone to the hospital that are chained to a bed, they're still in custody, but they're not counted when they die at that jail. Not to mention, they shouldn't have gone to the jail anyway. They should have gone to the hospital anyway. They should have been treated at the jail, and they was not. A lot of these jails deaths are happening because they're not getting the medical treatment that they need. They're not getting the mental health treatment that they need. And a lot of these suicides are weird. Like I got a phone call, someone had a bag over their head with their hands tied behind their back, their feet tied behind their back, and they classified it as a suicide. That's an issue. These are human beings, and our people are dying. And a lot of these people, like I say, every year I come here, a lot of these people behind the wall are innocent, and they have a right, all of them have a right to be treated with dignity and with medical care, preventive care. They should not be dying the way that they're dying. And you all know me. You know what I seen when I was behind the wall. They don't deserve to be treated like that. So I urge you all to please vote favorably for SB 036. Any other questions?
Thank you for that answer, and thank you for what you do, and thank you, Senator Benson, for putting in this bill. It's long overdue.
Thank you, Senator Benson.
Excellent. Thank you very much. All right, now we'll hear from Mr. Chambers. Welcome.
Greetings, President, Senator Will Smith, and the Judicial Committee. I am Nasir Mathis Chambers, support Senate Bill 36. I'm a freshman at St. Mary's College of Maryland and a member of several campus organizations, one of which includes a sitting senator of the Student Government Association. I have also started an internship for social justice and civic engagement with Helping Ourselves to Transform under the leadership of Dr. Carmen Johnson. Imagine a place where no life is lost unnecessarily behind bars. The Maryland Deaths in Custody Oversight Board, established by Senate Bill 36, will be a decisive step towards this reality. As a relative to individuals impacted by the Maryland correctional system, I urge you to pass this bill, not just for our future, but for the future of incarcerated individuals. As a young leader preparing myself for the road of politics, I have an understanding of the crisis of in-custody deaths requires immediate action. This oversight board will spotlight these tragedies to ensure accountability and prevent future incidents. It will enhance better medical and mental health services with preventive measures and medication management aiming to prevent deaths. Prisons should facilitate reflection, not be places of torture or end of life. We as Marylanders must be committed to upholding the fundamental rights of the incarcerated by valuing their lives. This isn't just about statistics, it's about real people. I've seen the scars both physically and emotionally left by the system in our community. Let's break the cycle. This oversight board can be a beacon of hope for those inside and families like mine seeking justice and change by making SB 36 a law. We want Maryland to continue to be a place of dignity and safety. Thank you for your time on this matter. I pray that this bill will be voted on and passed into law. Thank you.
Thank you very much. Questions from the committee? Seeing none, thank you very much for joining us. Thanks for hanging in there with us. All right, with that, that'll conclude the hearing for Senate Bill 36. Murphy?
Yes.
Oh, Tegan Murphy?
But it's probably me. I set up.
Yes, I don't have a Tegan, I don't have a Natalie. I'm sorry. I'm sorry. Oh, okay. Come on up. I think we have you only as written down. There may have been a mistake in the entry.
Oh, sure. I apologize. Thank you so much for allowing me to speak. My name is Natalie Murphy. I'm an intern at Civil Rights Corps. I'm a student at the University of Baltimore School of Law, and I will become a public defender this fall. I'm asking you to support this bill because one of my very first clients was almost stabbed to death in Baltimore City's central booking, and nobody would tell me why or how. When he was in surgery at Maryland's Shock Trauma Center, nobody called his dad, nobody called his girlfriend, nobody called his attorneys. When I finally got to talk to him, he said he was just relieved it wasn't as bad as when a correctional officer hit him the previous summer. What happened to my client was not unique. In fact, the community organizers, attorneys, and teachers proposing this bill wrote a report that you've heard a lot about today. I won't repeat the statistics, but I'll summarize a few key findings. Even a few days in jail can be deadly. Most people who die in custody are presumed innocent. In custody death is a problem born of poverty and racism. There are compelling reasons to believe the Maryland Office of the Chief Medical Examiner is misclassifying deaths as natural when they are actually due to violence or neglect, especially medical neglect. Finally, massive structural barriers conceal key information about in-custody deaths from the public and the deceased loved ones. Too many people are dying in custody in this state. Worse, Maryland residents know very little about what's happening to their loved ones. This bill will bring transparency and accountability to help protect my client and the 15,000 others imprisoned in Maryland jails today. You can help. Support our bill today and vote yes on SB 36. Thank you for your time.
Thank you very much. Questions from the committee? All right, with that, that'll conclude the hearing for Senate Bill 36. Thank you, Senator Benson, and to the panelists. We'll now move on to Senate Bill, Senator Watson here. Hey, Senator, how are you? Senate Bill 139, Senator Watson. Senator, would you like to bring up your panel? It's Mr. Dews and Cam Bridges. Cam's here.
Good afternoon. Good afternoon.
Chair Smith, Vice Chair Wall Striker, and members of my former committee. I'm proud to bring forward and asking for your support on Senate Bill 139, driver's license suspension for child support arrearages. Colleagues, this is the third time that this bill has come forward, and the last two times it passed unanimously out of this committee. The only difference between this bill and the prior year's bill is that I've added an amendment which includes a preamble, and the purpose of the preamble is to clearly state that the state intends to ensure that those parents who have the ability to pay can, and those who do not have the ability to pay are not unduly harmed. That's the summary of the preamble. In a nutshell, this bill has two provisions. It says that anyone who makes less than 250% of the federal poverty guidelines cannot have their driver's license taken. Federal poverty guidelines is right around 14,580, which puts that amount at 36,700. So if you're making less than that amount and you fall behind, you cannot have your driver's license taken. The other thing that this alters is that the bill in its current capacity says if you are 6 months late, you can have your driver's license taken. 60 days late, you can have your driver's license taken. However, if you are 120 days late, you have up to 120 days to be late if you have a CDL. So in one case, it says it recognizes that on one hand, you have folks who need the driver's license to get to work and totally disregards those who use their regular vehicle to get to a work that don't have a CDL. That's the summary of this bill. And again, it's the same bill with the exception of the preamble that has passed this chamber twice before. With that, I'd like to turn it over to my two witnesses. You can go ahead and do it.
Yeah, podium, does it matter? Does it matter?
You can do it from there.
Podium, okay.
Podium.
Just take care. My bad. Good afternoon, Christopher Dews representing the Center for Urban Families. This is an issue been working on for many, many years. It's passed out of this chamber unanimously twice now, just got to work on the House. And just wanted to quickly highlight that this piece of legislation, as a friendly reminder, was a recommendation from the former federal chair of the Child Support Administration. We've worked with DHS on this for many years. And the last thing I just want to kind of highlight is simply that a similar piece of legislation in California also passed that simply said that area media income, if you make less than 70% of the area media income, then they don't touch your license. So there's already precedent for this. If you guys can just do what you have done in the past and do what you do best, move favorable, we're good to go. So ask for favorable report. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Cam Bridges. I'm the Senior Public Policy Advocate for Job Opportunities Task Force. I'm not going to waste your time reiterating what the bill sponsor has already stated, as well as my fellow panelists, but we appreciate you passing this piece of legislation last year out of committee and appreciate the fact that it passed out of the Senate unanimously. And we ask that you give it a favorable report. So thank you.
Thank you so much. Questions for this panel? All right. Thank you, Senator Watson. Thank you all. We will hopefully move quickly on this bill. That concludes the hearing on Senate Bill 139. There is no opposition to the bill. Senator Muse, are you good to go? Wonderful to hear. All right, let's move to Senate Bill 174. Senator Muse.
Thank you to have a panel and come up to the table. Appreciate it. Thank you, Mr. Chairman and members of the committee. This bill is somewhat like the bill before me, and I believe there's another bill that will come after me. And although this bill does not do what I'm about to say, I'll tell you what it does do. I really don't think anyone who is trying to pay child support in any way should have their driver's license suspended. So for the record, that's where I am on it. Anthony Muse for the record, and I'm presenting this bill 174, which ensures that driver's license suspensions for inability to pay child support are used in inappropriate cases. That's what this ensures. I'd like to, and for the panel, I have Christopher Dews with the Center for Urban Families, Stacy Binsky with Maryland Legal Aid, and Kim Bridges with Job Opportunities Task Force. As we all know, mobility is the key in Maryland's regional economy. The Census Bureau reported that almost 40% of Marylanders travel outside of their county for employment. The statistics is more pronounced for lower income communities of color, where there's a scarcity of jobs available by public transit. For example, only 8.5% of jobs in the Baltimore region can be reached within an hour, one way by public transit. More concerning is that many employers in these communities won't hire individuals without a valid driver's license, as driving is central to many positions, as you know, such as construction, Uber, Grubhub, door-to-door sales, and et cetera, et cetera. These jobs are increasing. Therefore, a valid driver's license in a vehicle are necessary for economic sustainability. There isn't a direct impact on Marylanders. The suspension mechanism is automated through the Child Support Enforcement Agency, and no determination is made as to whether a suspension would be appropriate. This is what this bill changes. Maryland Legal Aid and the University of Baltimore have reported individuals who are disabled, not in arrears, or with primary custody of their children, having their licenses suspended. In terms of child support debt across Maryland, 50% of non-custodial parents in the state child support program caseload were employed in 2017, and 43% of these persons earned wages or less. They earned wages that were very minimal. And these people owe an average of $10,000 in unpaid arrearages. They will never pay down this debt, especially when the current law magnifies the issue by crippling their mobility. 2, a report cited by the ABLE Foundation found that 42% of individuals who had their licenses suspended lost jobs as a result of that suspension. 42%. So on the one hand, you're saying, pay your child support. On the other hand, you're going to take a license to make sure that that never happens. 45% of those who lost jobs could not find another job, and 88% of those who were able to find another job reported a decrease in pay. It's counterproductive to everything that we're trying to do. So what does this bill do in a nutshell? It seeks to resolve this by ensuring that before the Child Support Enforcement Agency notifies the MBA of one who is in debt, who's in arrears, a circuit court hearing. And this is different than the other bills because there's no one standing between them and those who make the decision to revoke their license. And so the difference in this bill than many is that a circuit court hearing needs to be established to determine if the suspension is appropriate. It proceeds to determine that a suspension, if it's not appropriate, they are able to say that. Now, this doesn't mean everybody can appeal because there are a list of criteria that you have to go through in order even to get to that stage. So if people say, well, it means any and everybody, that's not the case. To determine, here are some of the things that will help to determine whether or not one is eligible for this exemption. Number one, if the minor lives with the parent. If the obligor is disabled and unable to work. Number 3, a suspension that would cause the one in debt to be out of compliance with another court order. Number 4, suspension would ruin the ability to assist the custodial parent with the child's transportation needs. 5, the suspension would risk the loss of employment or employment opportunities. Number 6, the obligor could not pay or is making arrangements to pay. Number 7, amen, I like that. If the suspension would place an undue hardship on the obligor of the family. Now, the reported, number 7, the reported arrearage amount is, if it's not accurate, because then sometimes that's the case, who will make that determination? And then finally, the administration has agreed with the person owing the debt through a payment incentive program so that this is not automatically done. There's a process that they choose so that they can determine who will and will have their licenses suspended. It doesn't, in closing, it does not make much sense to take away a person's ability to work and then say, we're going to hold you accountable for not making your payments. We should be doing just the opposite. And this is not to minimize and to say that one should not. Absolutely, one should pay, one should meet their obligations. But in those cases where that is not able to happen, someone should be making that decision and someone should be making sure that justice takes place. So I urge a favorable report, and I'm going to turn it over to our panel now. I think the little one wants to talk first. You want to talk first? Yep, I can tell. Wants to talk first. Here we go. Thank you.
Good afternoon, and thank you for allowing me to have the opportunity to speak here today. My name is April Hamilton. I'm a resident of District 8, and I support Senate Bill 174, House Bill 1311, to ensure that driver's license suspensions and inability to pay child support are used in appropriate cases. I have a 10-year-old daughter from a previous relationship and a 9-month-old that I am raising alone. I left my previous relationship after surviving multiple domestic violence situations with my ex, the 10-year-old's father. After I left, I went to a domestic violence shelter, and the obstacles were insurmountable. With no familial support, I struggled to obtain stability, to gain a license, to have a job and a car and housing. At one point, I lost custody of my daughter, and my ex placed me on child support, where I had my wages garnished and my license suspended. My quality of life significantly plummeted, and I had to reach out back to my abuser to plead with him to drop the order, which he eventually did. I am thankful that the situation worked out the way it did, but no one should have to plead with their abuser to repeal a child support case. Years later, I took the opportunity to better my situation, and I moved to Alaska to work on a cruise ship as a waitress. During this time, my ex placed me back on child support for my daughter, and because I was not in the state, I did not receive the appropriate correspondence to push the order back. I now owe him $20,000 in arrears, and my license has been suspended since April of last year. There is no way that I can pay down these debts. I have been frantically searching for employment and have found several decent opportunities, but have been turned down due to not having a license. If this bill were to pass, I could make a case in court, retrieve my license, and improve my ability to support both my children and improve my circumstances in life. Please pass these bills.
Thank you. Do you want to introduce us to the young one?
Yes, this is my son, Oberon.
Hello. Hey, buddy.
Say hi.
Welcome.
Now you're quiet.
Thank you for joining us.
Want to stay seated? Sure.
Good afternoon, Chair and members of the committee. My name is Stacy Bensky, and I'm an attorney at Maryland Legal Aid. The MVA reported over 20,000 license suspensions for child support in 2023. That is staggering. When you know the stories and faces behind that number, it hits even harder. I assist parents with license reinstatements, but often the damage has already been done at that point. They already have a criminal citation for driving on a suspended license. They already lost their job or had their car impounded or missed an important event in their child's life. Fixing it on the back end is too late, not to mention it's not a permanent fix because the automated system used by the child support agency will simply suspend them again, even if that means they will lose their job and even if they now have custody of their child. Parents are resuspended again and again because of the agency's unfettered, arbitrary, and predatory automated system. This bill will help break the cycle of poverty by allowing people to secure and maintain steady employment. Steady employment can be garnished for child support. Steady employment means taxes for the state of Maryland and tax refund checks that can be garnished for child support arrears. The answer is not placing barriers in the way of employment, but making employment accessible. I've stood before this committee for several years advocating for reform of the Child Support Agency's driver's license suspension system because there's a river of Maryland residents drowning in a flood. I can help them one by one, but you have the power to put up a dam and stop the drowning. So please stop this automated system. It's a harmful use of government power and presents serious constitutional concerns that should worry lawmakers of all stripes. We urge a favorable report for this bill that will provide due process and allow the judiciary to make determinations of appropriateness before license suspension. This will bring Maryland in line with federal requirements. And lastly, I just would urge you to read my testimony, which has client stories that I do not have time to tell you in 2 minutes. And thank you for the opportunity to testify.
Thank you.
Good afternoon. My name is Zach Alberts. I'm a resident of District 46 and the Senior Manager of Strategic Initiatives at the Center for Urban Families, a workforce and family strengthening program in West Baltimore. We support Senate Bill 174 because it supports families by ensuring that the harm caused by removing a parent's ability to drive is only used in appropriate cases. At the Center for Urban Families, we help individuals that live in the most underserved, underrepresented, and disconnected areas in Baltimore City. As you have heard in previous testimonies, 92% of jobs in the Baltimore metro area take an hour or more to get to on public transportation. That's if the buses come on time. As our clients climb their way up the economic ladder, a car is more often than not their first significant purchase, as it opens up a world of economic and parenting possibilities. Jobs that require driver's license, like qualifying for your CDL and operating an 18-wheeler, are some of the most popular paths out of poverty for our members because they have relatively low barriers to entry and can pay upwards of $80,000 or $90,000 a year. These license suspensions unnecessarily and unproductively block access to high-wage earning employment. A 2020 study by the Baltimore Sun found that the average child support arrearages of 1,700 non-custodial parents in CFUF's 21217 zip code was $16,500. That is 45% of that zip code's annual median income. Our clients' arrears are even higher at $24,000, and the same parents reported being out of work 18 of the last 24 months. Our clients are doing the right things. They're striving to be better parents, better community members, and better citizens. Suspending their license is not a minor inconvenience. It's a major action that can significantly derail their life. The purpose of child support laws is to help Maryland families and children. This practice only hurts them. I urge a favorable report for Bill 174. Thank you.
Christopher Dews, also representing the Center for Urban Families, Cornerstone. So just quickly, just want to highlight very quickly, since every one of the talking points has been taken, and that's great, that the federal law, Title 42-666A, just want to be clear, because I know that there was some conversation in, I think it was an informational letter that may have been sent to you all with regards to the AG's office. We've been working in tandem with them for this entire process. So just want you guys to know that the federal statute demands that the suspension mechanism is only used in appropriate cases to increase the effectiveness of the program. For that specific reason, we have drafted this legislation to ensure that there is a due process standard so that there is an actual definition of appropriateness. So I just wanted to highlight that because I know there was some confusion about the federal funding. This bill would not touch that based on the conversations that we've had. There's also, I also was informed that we're going to need 17 new attorneys. There's already a contempt docket for individuals who do not pay their child support. All we're really doing is taking that same docket and then kind of fusing them together. So now instead of just contempt, you're also examining a person's ability to secure the license as well. We actually specifically coded that data in there because we've had judges, I want to say one testified last year on a similar piece of legislation that said, listen, I just unsuspended this person's license and now I'm seeing you again in 2 months. Well, just because the judge may have
required that person's license to not be suspended because of the automated system. 2 months later, it gets suspended again because there is no process who makes the determination. So we're just trying to simplify the process for the judges, for everybody. And also just want to highlight very quickly. No, actually, that's it. Yeah, that's all. So we urge a favorable report. Thank you.
Great. So I saw Senator West first and then the sponsor.
Thank you, Mr. Chair. Mr. Dews, don't sit down.
Yes, sir.
So I spent a little time during the beginning of this bill trying to compare this bill and the last bill.
Yeah.
Which are very similar. And I finally, in frustration, gave up because I wanted to listen to the testimony and I couldn't do both. So since you're testified for both bills, could you please explain to us how this bill differs from the last bill and which bill of the two we should pass?
Well, obviously, my default reaction is that you should pass both. And the reason why is because one is based on your income threshold. And so, again, that was a requirement or a recommendation from the former federal chair of child support. But that, of course, only affects those making less than roughly $37,000. Right. So the way if these are actually, let me be clear, these are companion bills. They're not in competition with each other. We've had plenty of conversations with both sponsors on the House and the Senate side to ensure that they're different. Senator Watson's bill, to be specific, is saying if you make less than 37,000, we don't touch your license. Wage garnishments, all that stuff still happens. We just don't touch your license based on your income. This piece of legislation is doing an entire analysis of the individual. Do you have possession of the child? Are you disabled? Would this impact your ability to secure employment? Would this put you at risk of another court order? So this is actually doing an examination of the individual. So if you wanted to put both of them together the way that it would look, let's say both bills were to pass, right? The way the statute would then look, it would start off by saying if you make less than 250%, the suspension mechanism does not apply. That's what 10-119 would say. Then the rest of it would say, for those who do, for those of which this does apply, the suspension mechanism, here are the criteria that need to be in place before you suspend their license.
Okay.
Yeah.
All of which makes sense. The problem is that each bill, in some cases, wants to amend the same section of the law, but amends it differently.
Indeed.
So it will be hard for us to pass both bills because they're in conflict, literally in conflict. So could you, we can talk about it offline later on, but it would be helpful, I think, if somebody could try to merge the two bills and put them together in a way in which they're not in conflict. And they're both very consistent in their amendment of the law.
I will let Stacy speak to this. I just want to say again, had conversations with the Office of the Attorney General. And I do want to highlight, because in case you guys did get a note, the person who probably wrote that note was newer to the administration. She just took that position. We've been working with Hannibal on this. And so in our conversations with them and in our conversations with the Child Support Enforcement Agency, they have not highlighted that there is a conflict on either of those two bills if they were to pass at the same time. It's been a subject of much conversation, but we can definitely talk offline and I can pass it to Stacy to kind of speak more to that.
Yeah, why don't, this involves more of the technical drafting portion of it. So why don't we kind of stick on the substance and go to Senator Muse and then we can do the editing offline.
Absolutely. And let me say this for the record, for Senator Watson, who is my Kappa brother, to anyone in here who's not a Kappa, you won't understand that. But it doesn't really, it doesn't matter as long as something happens, whether they merge them. But as long as something happens, my question to you is, one, how is this lottery system set up? Because it seems like it's a lottery system and this system just picks anyone, and whoever that system will pick, they really don't know anything about the person. They just say, eeny, meeny, miny, mo, but then that person automatically gets the letter and it's automatically suspended. How does is that computerized? If you don't know, you can get back to me.
That's an excellent question for Stacy Bensky.
I want to know how does that happen? And number two, I would feel better having someone involved who can take into consideration everything about that person before making such a decision that causes such economic devastation. Well, devastation period to a family. So how is that done? And I'll stop there.
Sure. Yeah. So What happens is the way that the law is right now, that's 10-119 of the Family Law article. It says that the agency, the child support agency, may suspend your driver's license if you're 60 days in arrears. So it's not a shall, it's a they may. However, what the agency has done, what they've decided to do to implement this is they have an automated system. So they basically made it a shall. So they have it's a lottery system where anyone who has 60 days or more of arrears is automatically in this pool of people who might be picked each month. And there's thousands and thousands of people that are picked each month, which ended up, and most recent numbers from the MVA that we got just last week were over 20,000. I think it was 20,512 exactly, that were suspended. So that's why, so there are current exceptions in the law already, but what happens is because of this lottery system, basically when these exceptions were implemented years ago, when they were put on paper in the law years ago, they were never ever implemented by the agency. So even though right now it says if your license suspension would be an impediment to employment, that they are not supposed to suspend your license. It says if you have a verified disability, they're not supposed to suspend your license. I have clients all of the time who lose their jobs. Literally lose their jobs because their jobs are driving. And I have clients all the time who their only income is SSI and they are disabled. And they want to help out with their kids in other ways. And even the custodial parents will say to me, I don't know why their license is suspended. Now they can't even now for visits, I have to drop the kid off. Like this is not helpful for me. But again, it is all because of this automated lottery system, because if they still have 60 days of arrears, then they're potentially just going to have their license suspended again and again and again, all due to this automated lottery system. And Senator West, to speak to your question, that is the difference between the two bills. However, the two bills do work together. So this bill would get rid of that automated system. So it's a full systemic fix, because the automated system is what we see that harms communities as a whole, that stops people from working. But however, the bills would work together, because basically the other bill, which we also support, and we did submit written testimony for that bill as well, and definitely would have also done oral had there been more speakers allowed for that bill. In any case, I apologize, getting back to where I was. So for the reason the two bills work together is that the other bill, Senator Watson's bill 0139, is an exception. It adds another exception to 10-119. This bill 0174 would make sure that that exception actually gets implemented instead of just being another exception added on to 10-119, that the agency's system continues to operate as if you all sitting up here, as if the laws you make mean nothing, because right now that's how their system is operating.
So one of the things that we need to look at, I think, would you agree, is that as I'm saying, this automated system, it is such a cold and callous way to choose something that's going to change somebody's life without human resource, without a human involved, to look at everything. So any, many, miny, mo, who cares about your situation? And that's why judges complain that when they say, I'm not going to do anything, 60 days later, the same person, because there's no one involved. And that's and that we've got to talk about that. We've got to change that process, because that is not a proper way that we should be administering anything that changes a person's life. So thank you.
Absolutely. Thank you. Let's go to Senator James, who has a question.
This is going to be probably follow-up for anybody that's testified on this bill or the other one, and even my good friend. I get the point, and I can see where, while the idea was, people thought it would work perhaps to do license suspensions, it probably only works with certain populations.
Higher income populations. And that's what this would allow.
Right. But what I just want to be sort of a voice for all the women, and they are the vast majority are women who are taking care of children, and they are not getting child support or enough child support.
Sure.
So not for right now, really not for right now, but I want you all to follow up. I'd like to hear whether you work with women's groups about.
And I can speak to that.
That's good. And then tell me, what are some ways we can help these women as we pull away these provisions as ineffective? I'd like to tell them, we aren't just pulling things away, we are adding.
Sure.
We are finding better, smarter strategies, because this is really about children more than anything else. And child support is at the heart of both of these bills.
Absolutely, sure. So I can speak, so actually
Well, I
this,
was gonna say, this is not on this bill, and
It-
I'm gonna respect, we haven't been here a long time.
Sure.
So I don't want to delay this bill hearing. I want
Okay.
you all just to hear me before
Well,
you
if-
leave, because me running after you and saying, let's get back to me on that, and let's not do it at this moment. Thank you, Mr. Chairman.
Sounds
Okay,
good.
well,
Thank you all. Any
Second
other
that.
further questions for this panel? All right, seeing no questions for this panel, let's call up others. Michelle Smith, Franz Schneiderman, Elizabeth Hilliard, Cam Bridges. I know some of you testified for the previous bill. If there's any Me Too's among this group, you are welcome to do so, as we have a number of other bills today, and Senator Washington is here for the next bill. We also have Antoine Gaines come up as well. Whoever would like to go first.
Mr. Vice Chair, members of the committee, my name is Michelle Smith. I'm here on behalf of the Maryland State Bar Association. I represent and I'm the co-chair of the legislative section of the Family Law Section Council. Hello. I know the hour is growing late and I'm not going to repeat any of the testimony from the prior excellent witnesses. I'd like to immediately address the last question from Senator James. We are family law practitioners. We're private practitioners. And I can tell you anecdotally that many of our thousands of practitioners have no idea that there is a lottery system like this. And most of the people that we serve, our clients, also have no idea. So when they are owed child support, the women you speak of, and they call the Office of Child Support Enforcement, having a case there, and they say, you know, maybe I just got a modification, or the parent, I know they're making this particular amount of income. He is in arrears over 60 days. I would like you to enforce my child support order. And do you know what they hear? That will be enforced when the lottery system pulls him up, and not before then. That is why we're in support of this bill, and that's why we urge a favorable report.
So let's get rid of the lottery, and when she calls, can they then say,
Yes.
yes, well, we got rid of the lottery, and we'll go ahead and do that?
Yes,
Is that what will happen?
Yes, well, I
When she
hope. I
calls?
can't speak for the agency, but it should
So all
happen,
right.
and here's why. Because the bill provides that the agency has to go in and particularly choose the individuals that they are going to prosecute.
Good, and we'll follow up. I don't want
Yeah.
to, I got people a little sidetracked now. I don't want to be the one.
No, no,
we're
no.
going to do
I
this
think it was
hearing.
an
Thank
excellent
you.
question. It was what I was going to address already
Great.
in my testimony.
Thank you.
But for all of the reasons that have been stated, we support and urge a favorable report from this committee. Thank you.
Good afternoon, Acting Chair, remaining members of the committee, Elizabeth Hilliard with the Office of the Public Defender. Me too to everything they've said, and it is frequent that our clients that we represent after they've been charged with driver's license suspensions, they don't know why or even that their driver's licenses have been suspended due to child support arrears until they have been pulled over and the cop has run their license. This will fix that. We urge a favorable report. Thank you.
Thank you, Senator Sidner, members of the committee, for the opportunity to address the bill. I'm Franz Schneiderman. I work with a group called Consumer Auto that works to protect Maryland drivers and Maryland consumers. You know, we've talked about this issue before. I do want to point out that, as the last witness noted, in a lot of cases, people are getting their driver's license suspended and in this way without even being notified about that, and that each act of driving without a license makes you liable to 30 days in prison and $1,000 fine for each offense. So people can quickly get into more legal and financial jeopardy without even knowing, that they've been violating the law. I want to say, that I think this is a great bill in particular because it addresses the problem more fundamentally. It requires an affirmative court order to cut off someone's license and sets fairly clear and restrictive conditions for such an order. It has to be established that the debtor actually can pay the money, that the money can't be collected or garnished in other ways, and most importantly, that it ultimately serves the best interest of the child. And because it's a court order, there should be a process of notification, so you wouldn't have the problem of people driving driving illegally without knowing that they were violating the law. So I think this is a great way to address something that's been a problem for a long time. Hope you'll give it a favorable report. Thank you.
For the record, once again, Cam Bridges with Job Opportunities Task Force. Again, me too to everything my fellow panelists have said, but I also want to highlight that the economic advocacy group Prosperity Now highlights that 40% of Americans are a single missed paycheck away from poverty, and even a single week's worth of time to correct an erroneously suspended license can lead to a lost job and have devastating consequences for low-income Marylanders. And as my fellow panelists at Legal Aid can attest to, speedy corrections for an improperly suspended license are simply not the reality for many low-income Marylanders. And at the end of the day, lost jobs for obligors is not in the best interest of the children. And this bill takes that into consideration and ultimately protects children from being a casualty of the very enforcement mechanism designed to help them. So with that, we urge a favorable report. Thank you.
Thank you. Any questions from, no questions? Thank you all very much. Antoine Gaines.
Yeah, unfortunately, that was one of my clients. He unfortunately was not able to make it here today.
All
But
right.
it's, again, like I said, I would urge you to just review my testimony. I do have client stories in there.
All right, how about Michael Ross? That another one?
That was another one of my clients, and I did want to, if I could just say, both of those clients have custody of their children when they're.
You want to speak in the mic?
Sorry. Yeah, since they couldn't, if I can just say, both of those clients actually had custody of their children when their driver's licenses were suspended. So if I can just give that does happen a lot at Legal Aid, because we do represent both custodial and non-custodial parents, and we do see that very often.
Thank you very much.
Thank you.
That'll end our bill hearing on Senate Bill 174. Next, we'll have Senator Washington for Senate Bill 85.
Thank you so much, Mr. Chair. My sponsor panel. I just have two. Okay. So committee, just before I get started, wanted to let you know there were many people that wanted to come and testify in person on this. And again, recognizing, the great amount of people, we reduced it to one person here in person and one person via Zoom. I would like to, however, draw your attention to the numerous supporters of the legislation. And also during the course of my testimony, if you will allow, I will be highlighting some of the points that you may have heard, that you would have heard if people testifying here. So for the record, I'm Senator Mary Washington. I'm here to ask for your favorable report of Senate Bill 85, Limited Worker Cooperative Associations Authorization, and we're calling it the Maryland Limited Cooperative Associations Act. In short, this bill will carve out a place in existing LLC statute to officially recognize worker cooperatives as legitimate businesses, that these businesses can incorporate, that they can receive loans, they can run their business in compliance with state law. If passed, Maryland would join 30 other states with such laws. Some of these states include Connecticut, Delaware, Illinois, Massachusetts, they had the first such law. New York, North Carolina, and Virginia. Worker cooperatives are also called worker co-ops, and they are businesses that are owned and democratically governed by the workers. Any business in any industry can be a worker co-op. We see co-ops in service, retail, technology, the media. According to research by the Aspen Institute, cooperatives are more resilient to economic shocks. They experience lower turnovers among their workers and have a higher productivity level than traditional businesses. Co-ops also provide an opportunity for workers to build wealth. And this was my first interest in this model of worker ownership. And also I represent a community or communities in Baltimore City where there is a commercial corridor and there's an aging commercial corridor with aging owners. And I was looking for opportunities for if the owner no longer wanted to operate the business and the child was not interested in operating the laundromat or whatever it was, that this could be an option rather than closing, that there could be an option for the workers. So that's what introduced me to this topic in general. Cooperatives also tend to be led by women and home to many workers of color. And so worker cooperatives can be a pathway to narrowing racial wealth gaps. And many of the gaps that we see, and that is also our values, that we want working people to not just have a job, but also have a way to gain wealth. So ownership in their place of employment is a pathway there. One worker co-op you may be familiar with is Equal Exchange. And there are over 30 known co-ops in Maryland. In Baltimore City, we have Red Emma's. I just had coffee there the other day. There's a Baltimore Bicycle Works, Earthbound Rebuilding, Core Staffing, and a Greener Kitchen. Also in Mount Rainier, there's Glute Food and Resolve Financial Cooperative in Tacoma Park. Although employee-owned can describe many different structures, including worker cooperatives, it is most commonly used to describe companies with employee stock and an ownership plan. So that's the ESOP. So I believe one of the letters, or there's been a say, why don't they form an ESOP? And while an ESOP company is 100% owned, it doesn't completely operate according to worker cooperative principles. And that's what's really key. So they would not really qualify as worker cooperatives. However, a worker cooperative and an ESOP are not mutually exclusive. Both are employee-owned, but they have different governance models. A worker cooperative statute is needed because while we have many co-ops in their state, they are not technically recognized as cooperatives. And instead, many have had to incorporate as an LLC, and as such have had to navigate a confusing and cumbersome process to start their business. LLCs, in contrast to worker cooperatives, as I said, have different governance models and different business principles. So they should legally be two distinct entities. LLCs are not beholden to worker cooperative specific laws, such as they don't require a one member, one vote as a part of their organization structure. Co-ops also face many difficulties when using an LLC entity, including the charges they have for worker compensation. So they're viewed as if they were operating like an LLC, but they don't. There's also a misunderstanding of their business model. And sometimes they've had to swap out, and the forms that we have for creating an LLC don't completely fit. And so if a loan officer or anyone's trying to understand what they're trying to accomplish as a business, it just doesn't fit for them. So by adding legal parameters to establishing a worker co-op in Maryland, we can improve and ease the process for a business that wants to be a cooperative to become one. We can also recognize them in statute. Again, to clarify, this bill does not actively promote co-ops over other businesses, nor provide any special tax incentives, et cetera. This bill simply creates a standardized legal structure for worker cooperatives. Now, the provisions of the bill, they establish this concept of a limited worker cooperative association. It allows for some existing LLCs or businesses to become cooperatives. It allows for multiple classes of membership. It requires a newly formed LWC to hold an organizational meeting. There are a number of criteria in the bill. We have amendments that we've requested and that are in the process of being drafted. After having some conversations with members, and in particular, while we've been working on this legislation for 2 years, in fact, we were going to introduce it last year, but I recognized that it was model legislation from another state and it didn't quite fit in with Maryland law. So we took the break to really look at that. And to get some advice. However, in January, we heard some concerns from the business law section, and I met with them myself for about 45 minutes to talk and say, let's work these out. My hope was that they would change their letter to letters with amendment, and they did agree that it could be amended to fix, and I'm committed to working with it. One of the concerns really had to do around with tax issues. And so we are working with the comptroller's office to address the tax specific concerns raised there. So you really can expect additional amendments. So we are really confident that we can address that. Finally, and I know there'll be, questions, but you've really heard some concerns about legally recognizing worker cooperatives, saying that it would be redundant and unnecessary. Redundant in our statute is not unprecedented. We do this to target specific audiences and to ensure that law is all encompassing, to provide realities for those that may seem as though they are omitted from existing statute. One example is that school discipline, which this committee has heard, is both in the education code and in the criminal code. And they are not in conflict. They both exist. And it was the desire of some school officials to say they wanted the same principles reinforced in their section of the code. Joining me here today are two worker owners in Maryland who will share with you some of their current hurdles. Anna Evans Goldstein is from the Baltimore Roundtable for Economic Democracy, and Kate Khatib it is on Zoom virtually, and she is one of the founding members of Red Emma's, a bookstore, restaurant, coffee house in my district, and they have amazing food, and it's a great staff, and a great business model. And they located right on Greenmount Avenue in an area that is can be very challenged, but also has a lot of opportunity. But because of their values, they wanted to be in a community where they're most needed. And these are the types of decisions that cooperatives are able to make for the benefit of all Marylanders. So after my sponsor panel speaks, I look forward to the conversation.
Hi.
Hello, my name is Anna Evans Goldstein, and I'm here on behalf today of BREAD. We provide technical assistance and small business financing to worker-owned cooperatives in Maryland, and we strongly encourage the committee to issue a favorable report. The central tenet of all worker-owned cooperatives is one simple democratic fact. The businesses are run by one member, one vote. The worker cooperative business model has been shown to raise standards across industries, raise wages and benefits for workers, ensure job stability, reduce turnover, and spur innovation. And BREAD has had the privilege of working with and providing funding for many businesses in Maryland. So we've had a front row seat to many of the struggles the businesses face. There's currently no worker cooperative statute in Maryland, so these businesses have had to wade through the options available to them and ultimately fit themselves into a category they don't fully meet. They're trying to fit a round peg into a square hole, and in choosing to incorporate as an LLC or another entity, they lose something of the nature of how they do business and their values when doing so. Now, at best, this means that governmental and financial institutions just don't understand their business. At its worst, it means that they might not reach break even due to paying exorbitant workers' compensation fees, or might not receive funding or permits because they don't fit a clear legal category. And Maryland is behind the times. There are 30 other states with worker cooperative statutes across the country. And we already have industry-specific cooperative statutes here in Maryland for housing, utility, agriculture. SB 85 is the result of years of experience trying to address the pain points of worker cooperatives forming in Maryland. It's crafted off of the best practices of previous legislation, and we want this legislation to make it easier for worker cooperatives to form and operate. So please pass a favorable support on this bill.
Thank you very much. All right. Yes, thank you. All right, Miss, is it? Kate, is it Katib?
Katib. Yep.
All right.
Katib. All right, ready for me?
Yes, ma'am.
All right, thank you. I am testifying today as a co-founder of Red Emma's, which is the oldest and largest worker-owned cooperative in Baltimore City. I'm in strong support of the Maryland LCA Act because it removes a lot of the barriers that cooperative entrepreneurs like myself face as we strive to build democratic workplaces that exemplify the principles of cooperation and collective management. I have seen firsthand how confusing and uncertain a mismatch between the principles of democratic workplaces and the existing options for business formation in Maryland create unnecessary challenges for small business owners. Now, my co-op was founded in 2003 as a 10-member LLC. We faced significant challenges around personal taxation, health insurance, and workers' compensation insurance as we grew, because both as workers and owners, we didn't fit the mold for the ways that these systems work, and we didn't qualify for the benefits that are normally afforded to employees. At one point, we actually incurred a $28,000 workers' comp insurance bill for a single year for a business that paid less than $300,000 in wages at that time. We eventually went through an expensive and time-consuming conversion into a corporation because it was the only way we could figure out to support our workers and have the ability to bring in community investment to support our business growth. If enacted, the LWCA would provide a powerful tool for future cooperatives by providing a template grounded in best practices and hard-won lessons for anyone starting a worker cooperative to adopt and follow. It removes many of the barriers to cooperative formation by giving us a clear and consistent way to exist as co-ops without forcing us to jump through legal hoops and hack something together while at the same time forcing us to continually justify our ownership structure. This act is one of the best opportunities we have to support a rapidly growing cooperative ecosystem in Maryland and build a more democratic economy for the workers and the communities who need it most. Thank you.
Thank you very much. See Senator West.
Thank you, Mr. Chair. First of all, let me thank the sponsor for bringing this bill. It's very imaginative and obviously needed. But let me tell you a story. Many years ago, a good friend of mine, a lawyer, a guy named Marshall Paul, learned that a state in Wyoming, to be specific, Wyoming had pioneered the creation of a new sort of business entity called a limited liability company. And so he thought he would spend a couple of evenings over the course of the summer trying to take the Wyoming statute and accustom it to Maryland, so Maryland could enact the same statute that winter. Well, it turned out to be a far more difficult project than Mr. Paul originally expected. And it became a major project of the business law section of the Maryland State Bar Association to try to take the Wyoming statute and then retool it to make it fit Maryland statutes. And even after it was enacted, in the ensuing years, more and more changes had to be made to it in order to make sure that it worked in sync with all of Maryland's other statutes. So when I first heard about this, my reaction was, we've got another situation like the development of the LLC law. And my question, the sponsor and I spoke, and my question was, have you checked with the business law section about this? And the answer was, you have. And in fact, Mr. Carlson, who has been the longtime head of the periodically the head of the business law section, is right here in the hearing room this afternoon. He's going to testify on the next bill. So it was interesting when I went through the testimony that my staff printed out for me this morning, that there's a 4-page letter from the Maryland State Bar Association's business law section taking an unfavorable position on this bill. So let me just read one paragraph on the first page of the letter, and so that people watching from home will know what I'm talking about. It says the business law section supports the concept of worker-controlled limited liability entities. One of our section council's members has met regularly with representatives of the Baltimore Roundtable for Economic Democracy, which is a proponent of the bill, to identify and address various legal issues raised by the creation of limited worker cooperative associations. Unfortunately, the bill as introduced does not address many important legal and tax issues, and without large-scale amendments, will create a class of entity with various unanswered issues that will pose substantial dangers to the people forming an LWCA, particularly workers. And then the rest of the 4-page letter goes on to enumerate in quite some detail, legal detail, the various issues that the bill currently raises as drafted. So I guess my question is, are you willing to sit down with the business law section? And there may be other law sections of the State Bar that also will have to weigh in on this to try to come to an agreement in terms of the language of a bill, which intelligently could pass the General Assembly and then do the job it's intended to do without running into snags along the way.
Well, I would say respectfully, if we held every single bill that we hear and pass in the General Assembly to that standard, not a lot of things would get done. The truth of the matter is that we do pass laws that they do require at time revision as they expose inconsistencies. We also, so I would say, first, that's the comment, that it's not uncommon for us to do that. 2, I think I said in my testimony that I spent 45 minutes explaining and talking with the Maryland Bar section about what we wanted to and needed to accomplish. And I left that meeting feeling very confident that we could pass something that would mitigate some potential harms. And I think I'd say finally, I don't believe that a single letter from a single entity should have veto power over the ability of the Maryland General Assembly to provide for legal business owners who are striving to be successful in Maryland, who are coming to us saying there's a problem with your existing law, help us fix it And that ultimately is our responsibility. Again, respectfully, I believe, and what I shared in the meeting, you know, with the law section is that as legislators, you know, we're partners in law, but we make laws and we make policy. And attorneys' job is to defend or to attempt to change that policy. We have different goals. So I would say that we should not, that the people in our state need this now, that I will continue to work to make it the best product that we could feel strongly about and defend on the floor. But I am not asking for your passage to be determinate on the agreement of free people.
Okay, well, let me just respond briefly.
Great.
I won't read the whole letter, but there's a long section of the letter which sort of concludes as follows. It says, this is problematic because there's a substantial body of law that addresses the rights and responsibilities of LLC members and of corporate officers and directors under various types of Maryland and federal law, none of which will be clearly applicable to LWCA members because it is a distinct type of entity.
And that's the point, Senator. Of course, you'll see, you know me, I've read that letter over and over again. I've researched it. The very points that they raise in this is why you need a separate entity. I actually found it kind of surprising.
Well, let me finish.
That they were comfortable with these sort of internal contradictions in their own document.
Well,
You can't produce it because they're different, but you should be an LLC, but you're not quite an LLC because LLCs do X, Y, and Z. So, you know, it's a little frustrating, but
I understand
please
you're
continue.
frustrated, and Marshall Paul, when he first started to draft the LLC statute, was incredibly frustrated when he realized how complicated this effort was going to be. So the last sentence says, accordingly, enacting the bill without addressing those other legal and tax issues will leave LWCA members, particularly worker members, in a precarious position. I think it would be derelict for us to pass a bill which the business law section of the State Bar Association believes will leave the people affected by the bill in a precarious position when we have the ability to go back and make the amendments necessary to solve the problems.
Oh, I think you misunderstood me.
Oh.
I have every intention of, as I said, I'm working with the comptroller. I also said in my testimony that there are some provisions around the worker compensation insurance, which is what I believe they were specifically concerned with. And so we have some language to address that. I'm saying that we are going to address as many as necessary, but all of these, I think you would agree and some would agree that some of them are actually prove the point that this type of business does not cleanly fit into existing law. Now, if you think it doesn't belong in the articles you know, if it should be its own separate article, then do that. But don't deny the ability for residents and business of our state to organize and conduct their business as they choose and to do that lawfully.
Well, let me just finish.
Yeah.
Last statement. I'm very sympathetic to what you're trying to accomplish. I'm not at all unsympathetic, but if we do it, we need to do it right.
Yes.
And not do it in a way which is going to leave people who get involved in one of these entities in a quote precarious position. Thanks.
Yes, you've said that. And then I'll just say that Professor Renee Hatcher, who I believe you have a letter from, she's a law professor at the University of Chicago, and her area of expertise is business law with a focus on worker to cooperatives. And for several years, she worked at the University of Baltimore School of Law in the Community Development Clinic. And she supervised law students from representing cooperatives. She's a part of, I've reached out to her today, and when I noticed her letter, it said, would you help us address some of the concerns? So I have every confidence that, again, given someone who's an attorney, who studies this, who has written a letter of support of the bill as drafted, by the way, that I feel as though we'll be able to move forward and produce a good document. Thank you.
Thank you. I think that it's a good, Bill, and I think that my colleague is saying the same thing that you're saying.
Yeah.
You would not be opposed to if we pulled together a little work group and we had some of the people
I
at the
want
table
to,
so that we
yes.
could say, here's the best way to pass this bill. You're open to that.
I want to do that.
Okay,
But come
we'll
to,
figure that
I want to do it and we could do it this year and we can do it. Yes.
Good. Thank you. Thank you, Mr. Chair.
Thank you very much. And again, how many other states have this type of?
30.
30 other states have this type of entity?
Among them, Virginia, Massachusetts, Connecticut.
Are taxes treated the same way in these other 30?
Well, they've resolved whatever issues they have with the taxes.
So there's a model out there to resolve.
Absolutely.
And you all are working with the comptroller's office?
Absolutely. That is what we will do.
Thank you.
Thank you.
All right, thank you very much, Senator.
Thank you.
Do we call the witnesses here?
So Anna, Evan.
Anna Evans Goldstein.
Oh, she
Oh,
already testified.
okay, got it.
Oh, I'm sorry, I'm sorry, there's 2 additional people, I didn't just. Oh, they weren't a part of my panel, but they just want to speak to them.
Okay, yes, yeah, we have them signed up. Come on up. Emily Lerman
Bernardo Vigil.
and then Bernardo Vigil.
Emily.
Good
And
afternoon.
then, all right, excellent. Go ahead. Yep.
Good afternoon. My name is Emily Lerman. I'm a worker owner and co-founder at Mira Kitchen Collective. We're a restaurant and catering business in Baltimore. My fellow workers are from Syria, Kuwait, Burkina Faso, Mexico, Nigeria, Honduras, Guatemala, and their cuisines are all reflected on our menu. I invite you all to come try our restaurant. We have delicious food. I can take credit for none of it. We formed in 2017 and the worker cooperative model appealed to us so that we could share in both the risks and the rewards of ownership and decision-making. We were eager to start our cooperative activities. We reached out to Bread for assistance and we learned we'd have to decide whether we'd elect to be an LLC or a corporation. We consulted a lawyer and still weren't sure of the best path forward. We elected to be an LLC since it was quick and easy and we'd figure it out later. We knew we'd have to resolve the workers' compensation issue. We learned from the best. We learned from Red Emma's. Once we had more than 5 owners, as this would have resulted in us paying unreasonably high workers' compensation rates that were not actually reflective of what we paid ourselves. As we grew, we realized it was even going to be more difficult to course correct. We engaged another lawyer who began to explain the process of converting to a corporation. This process is still underway and is incredibly burdensome. Because there's no cooperative statute here, there are very few lawyers and accountants in Maryland who understand worker co-ops, and as a result, most will try to talk you out of even becoming one. As a restaurant, we had to be mindful of how to change our entity structure so that we don't lose our catering and liquor licenses. Had we formed a new entity during COVID, we wouldn't have even been eligible to receive the grant relief that kept our business afloat. Worker cooperatives function for the benefit of its workers. We make decisions centered on the well-being of our team. As a result, we've sustained and grown our business and have been able to consistently raise wages and improve benefits. However, the financial and administrative burden we faced in determining our legal structure has taken away time that could be spent investing even more in our team and our business. I urge the committee to vote favorably in support of this bill, which will create better pathways for more worker cooperatives. Thanks to support and technical assistance from Bread, Baltimore boasts a thriving cooperative economy. We all work together for the benefit of our community, our customers, and our teams. We supported each other before, during, and even after the pandemic. We consistently confer on how we can create better and more inclusive workspaces with higher wages. I thank you for your time, and I hope Maryland can lead the way for thriving democratic businesses.
Good afternoon to the chair, vice chair, and members of the committee. My name is Bernardo Vigil Rendon. I'm a worker owner of Baltimore Bicycle Works, a full-service bike shop in Baltimore, Maryland, which was founded as a workers' cooperative in 2008, and I have been a member of for the last 10 years. The founding members of my cooperative were bicycle mechanics between the age of 21 and 24 years old, who decided to form the cooperative after years of organizing for better working conditions at another local bike shop. Our founding members were skilled mechanics, but none of our founding members had any formal education in business or in accounting. Our founding members initially made the decision to incorporate as an LLC. This decision led to a tax burden that was not commensurate with our actual rate of pay, as well as the inability to issue W-2s to our members, which led to large yearly tax bills as we were unable to pay our taxes on a paycheck-to-paycheck basis as most workers do. The complications around our taxes, which were downstream from our incorporation as an LLC, made it difficult to retain skilled workers who wanted to become members of our cooperatives, but were intimidated by the management of our unique tax situation, a situation accountants also found difficult to help us with because of the collective nature of the ownership of our business. In the intervening years, we have reincorporated as an S Corp, which has simplified certain things for our members, but leads to its own problems and complications, in addition to costing our business quite a bit in time and legal fees. Truly, one of the greatest benefits of the worker co-op model is the way that it allows working class people to build skills that have traditionally only been available to those with specialized college educations, all the while building wealth and equity in a business. I myself have been the beneficiary of this model as I've been able to learn business budgeting, bookkeeping, and other business skills that would not have been open to me as a mechanic. The lack of a dedicated worker cooperative statute places undue burden and difficulties on the working class people who are attempting to come together to better their communities and their personal lives through collective ownerships of a local Maryland business. And so I urge a favorable report on SB 85. Thank you for your time.
Excellent. Thank you very much. Questions from the committee? All right. Thank you both very much. Thanks for hanging in there with us. Thanks. Now we'll hear from our witness joining us virtually. We have Emily Wuki. Welcome.
Hello, my name is Lee Wuki. I'm the paralegal for the Workplace Justice Project at the Public Justice Center. We're in support of Senate Bill 85 because it allows workers to create worker-owned businesses using a corporate structure that's designed for worker co-ops rather than LLCs or other corporate structures. And what I want to highlight in this testimony is the collaborative effort that has led to SB 85 being presented today. So SB 85 is a product of literally months of work by the University of Baltimore School of Law's Community Development Clinic. So law students were under the supervision of Professor Jamie Allison Lee and Professor Peter Norman, who both have expertise in business organizations and cooperatives. These law students were able to study Illinois law, which is a successful model that has helped worker-owned businesses to thrive, and they adapted it to Maryland code. Starting in the summer and fall of 2023, advocates from the Baltimore Roundtable for Economic Democracy, who we just heard from, organized meetings with worker owners, the Public Justice Center, and members of the MSBA Business Law section. The UB Law Clinic was able to compile research on other state worker cooperative statutes while also taking into consideration the amendments put forth by the Business Law Council. So not only is this bill the product of considerable expertise, but it's also a reflection of collaboration amongst a diverse group of stakeholders. Advocates who are in favor of this bill are looking forward to hearing feedback on this bill and continuing to work with stakeholders to make this bill a reality. Because ultimately, the bill's focus is to allow worker co-ops to exist without having to relinquish their democratic values and governance structure. Thank you.
Excellent. Thank you very much. We have one question from Senator Sidnor.
Thank you very much. Did I hear you correctly that you had members of your drafting party that was from the State Bar Association's business law section?
So go ahead.
Yeah, I can speak to that. Sorry, the University of Baltimore Law Clinic is the group that drafted the law. Bread and the University of Baltimore and PJC, the Public Justice Center, met with the Business Law Section Council over months. We answered all of their questions. We talked to them about their concerns. The concerns that are raised in the unfavorable report that they put in were not given to us until early January.
Okay, so I guess I've been trying to figure out, is it a thing that when you have multiple lawyers, they may all look at it differently, or are these real true concerns that should be addressed?
From a very non-legal perspective, we had lawyers at the University of Baltimore draft the bill in coordination with hearing about the different pain points that worker cooperatives face.
Let me
And
go back. Are
the
you-
lawyers
are
at
you an
the,
attorney?
I am not an attorney, no.
Is the person on virtual, are they an attorney?
I'm not an attorney, I'm a paralegal.
Okay, then never mind. Thank you.
Sure.
All right, thank you both very much. All right. Anybody want to sign in? All right, with that, that'll conclude the testimony and the hearing for Senate Bill 85. We'll now move on to Senator West with Senate Bill 400. Senator West, you're up.
Thank you, Mr. Chair. It's a pleasure to be here and present Senate Bill 400. Senate Bill 400 is the annual bill to clean up and tweak Maryland's corporate laws. As usual, it's brought to us by the Business Law section of the Maryland State Bar Association. As we have in years past, Senators Waldstreicher and I are pleased to co-sponsor this bill this year. Senate Bill 400 has four components. By far, the most important component addresses the situation that could arise when a catastrophic event occurs, which makes it impossible for a quorum of the board of directors of a corporation to be readily assembled. New language is added to the Corporations and Associations article that addresses three scenarios of a catastrophic event. First, the bill authorizes bylaws to be enacted in advance of an emergency containing provisions necessary for managing the company during the emergency, and states that any corporate acts taken in good faith during the emergency in accordance with the emergency provisions will bind the corporation and will protect the directors and officers of the corporation from lawsuits premised on the contention that they acted beyond the scope of their authority. Second, the bill addresses situations in which emergency bylaws had not been enacted prior to the emergency and provides for meetings of the directors and stockholders to be convened with whatever directors and stockholders can be assembled under the emergency situation. Once again, the bill states that corporate acts taken in good faith in such circumstances will bind the corporation. The other three components of the bill are minor technical tweaks to the existing law. The bill clarifies the timing of when shares of stock are no longer deemed to be outstanding. It permits a limited partnership to serve as a resident agent for Maryland business entities. And finally, it clarifies the requirements for principal offices of limited liability companies and limited partnerships. I note that there is no opposition to this bill. And with me, Bill Wasserman? Jason Wasserman and Bill Carlson are here. And Jason is going to take the lead in answering questions and further describing the bill today.
Great. Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Jason Wasserman. I'm a partner at the law firm Shapiro Share in Baltimore and a member of the Committee on Corporation Law of the Maryland State Bar Association. Senate Bill 400 is the Committee on Corporation Law's annual miscellaneous bill. Senator West gave a great summary, so I'll be short, given we're late in the day here. I'll just supplement with a few comments. The Committee on Corporation Law meets throughout the year to discuss various emerging legal issues with the goal to improve the Corporation Association's article. To continue to make Maryland an attractive state for businesses to incorporate. We look to Delaware, the American Bar Association's Model Business Corporation Act, and other states when considering proposed amendments to Maryland's corporate code. Delaware and the Model Act have both enacted emergency bylaw statutes. The Model Act in 1984 and Delaware more recently. Both have revisited the emergency provisions in recent years in response to the COVID pandemic. Events such as COVID have sparked a national interest in these provisions. Maryland continues to be a destination for public and private businesses, including the leading state for real estate investment trusts, which are oftentimes formed as Maryland corporations. The revisions proposed by Senate Bill 400 are mostly technical in nature and will benefit Maryland businesses. The Committee on Corporation Law is in favor of and supports Senate Bill 400. Thank you for your time and consideration. We respectfully request a favorable report, and I'm here to answer any questions you have.
All right, thanks. Mr. Carlson, you're just here for questions, technical assistance. All right, got it. Questions from Senator Sidnor.
I was trying to read through your testimony and I listened to your testimony, but I'm not swayed as to why this is necessary. I mean, it's not, we're in the 21st century. We can, I think corporations can currently have calls done over computers. What are we attempting to resolve that where you can't get board members together to have a meeting? I mean, they operated just fine during the pandemic. So what are we trying to resolve here?
So a couple of things. One, if a corporation does not have emergency bylaw provisions, there's currently no statutory authority for these corporations to have more lenient notice requirements, more lenient quorum requirements, and to the extent you alluded to, they do not already allow for remote communication through Zoom or what have you, for more lenient procedures in that respect. That's for board meetings, for director meetings. For stockholder meetings, there's also no such avenue to have more lenient requirements. So, and there's another situation that wouldn't be responsive to something like a COVID would be if, for example, this happened in Georgia in the early 90s. So I'm giving you an example that doesn't happen very often. A private jet went down where all the directors on board were killed in the plane crash. So what the corporation had to do was convene a meeting of the stockholders, which is a time laborsome process, in order to elect new directors. Otherwise, they were in a period of a stalemate where they couldn't act without any directors that were alive at the time. This would solve that issue, although, as you allude to, it's not very, doesn't happen very often. And another thing that this statute would do would allow for corporations to, in their existing bylaws, to designate additional directors that would act as directors only during such emergencies. So if
so they can act to appoint new members, but they aren't able to act and do anything else in accordance with their bylaws and articles?
The rest of the bylaws continue to remain in effect during emergency, unless they're superseded by the emergency provisions. So, for example, the emergency provisions would say regularly a quorum would require a majority of the directors to be at a meeting. But during an emergency, you could have a third of the directors to achieve a quorum. So it more readily assembles that quorum so there could be encourages corporate action in times of emergency.
Have boards been sued because of something that they did in one of these? And I know catastrophic events is not defined, and I'm going to ask a question about that. But in one of these emergency situations, did that some board acted and were they sued because of what their board did? I mean, again, I'm trying to figure out what is the problem that we're trying to resolve here with this.
Well, I think the problem we're trying to be more attractive for companies to form in Maryland. This is available for corporations that are incorporated in Delaware, available in over 35 other states. The Model Business Act provides for these emergency provisions. So we're trying to be consistent with other states and provide another avenue that other states have already offered to their people that incorporate in their states.
Have boards in those other areas been sued because, I mean,
I don't know the answer to that.
Okay.
I don't know the answer to that question.
Okay, and I think within your in your footnote 1, you said that catastrophic events is intentionally not defined. What are you thinking about? What are catastrophic events in your mind?
So the way we envision this is there would be the legislative history that's written below the statute would give examples of some catastrophic events. And I mean, I'll read from the letter because off the top of my head. Could be of a widespread or company specific nature, such as a nuclear or atomic disaster, a cyber attack, an epidemic or pandemic, a mass casualty event, or an event that gives rise to a declaration of a state of emergency by the United States or by a state government. So those are some examples of some catastrophic events that would be inclusive of an emergency, but it's not restrictive.
Which is again why I'm asking the question, because I know the University of Maryland, the system, they had their cyber attacks are happening, they happen all the time. And I guess if I'm sitting, and if I'm not a director, but I'm sitting as a stockholder or someone else, do I want to give that board this kind of power if that's what a catastrophic event is? All right, it's a cyber attack. You should have had a risk management plan to kind of take care of that, right?
So my response to that is another part of this provision requires corporate action to be done in good faith. So we're not trying to mischievously create anything here by the statute. You're still going to have to act in good faith. We're not trying to circumvent existing avenues that need to be abided by enacting the statute.
And the last question that I have, would this be inclusive of non-stock corporations, this particular provision?
I'm sorry, what was it? Non-stock, you said?
Right.
Yes, this statute applies to the CNA article, yes. So that would be inclusive of non-stock corporations.
Thank you very much. Appreciate it.
Yeah. Thank you for the question.
Thank you, Senator Sitter. Thank you. All right, with that'll conclude the hearing for Senate Bill 400. We'll now move on to
Thank you.
Senator, oh, I'm sorry. Yes? Okay.
I said thank you.
Oh, thanks. Yes. All right, excellent. Thank you all. Good to see you both. Yeah. We'll now move on to Senator James, Senate Bill 89.
How's everybody's energy level?
I know. Senator, we've got your panel joining us. Mr. Rawlings is joining us virtually. He's here.
Very good. Good afternoon, distinguished members. Senator James, Mary Delaney James for Harford County. I think I'm going to be particularly brief, but if that in any way confuses you or you don't fully understand this bill or can't remember it from last year, I will go back and go through it painstakingly line by line. But I think what I just want to say is, last session, I'll remind you, I worked tirelessly, endlessly for hours to collaborate with the state's attorneys. They came in and supported the bill. The bill was late because of how much time I spent making sure this bill worked, complied with federal obligations. It's called CAPTA, which is a federal law about protecting children from severe child abuse, certainly death and fatalities and near-death fatalities, or even there's a requirement in that federal statute that this be publicly known and disclosed upon request. And our law doesn't do that. So with all that, we were able to get it nearly unanimous in this committee, completely unanimous in the Senate. So with that, I think I'll stop there and just point out a couple of nice developments. First of all, you might have gotten a letter from the public defenders opposing this bill. Well, guess what? I talked to them last night. I talked to them this morning. They finally got the bill. I finally got their concerns. They have withdrawn their opposition. So I'm delighted with that. And we're going to keep working. And if they have any more issues, I'll certainly work with them. State's attorneys put in a letter of support. So the only thing left is the Department of Human Services. And I am just going to take 1 second on that. I don't want to do this, but in case this just embeds in your mind, they do not understand the current law, and the three things they brought up are just not something that exists in current law. First of all, they feel that the issue of disclosure is discretionary with them. It is not. The current law, which I'm not changing, says it is a shall. They must disclose certain information. We're just trying to improve the process and make it more certain for people. They also talk about some kind of power sharing with local departments of services. They don't cite any language. I changed no language in the bill that relates to the relationship between the Department of Human Services and the local departments. So I just think that every year they submit some opposition. Every year we explain and show that it's not founded, and this is just a new letter and it's not founded. I want to just close with this. I co-chair the Committee on Children, Youth, and Family. We brought this bill, some of the reporting, and the expert from Georgia, the judge, former Judge Tom Rawlings, into that committee. And I can tell you that the whole committee was pretty shocked that we don't allow for disclosure under certain circumstances, and that generally the way the law works is they say no, and then nobody finds out about these very serious cases. And the issue there is public trust and accountability. So we are going to be consistent with federal law. It'll improve the system. And with that, I'll stop talking, but I would ask for a favorable report, and I'll answer any questions, but I think we'll probably take a witness.
Yes, thank you very much, Senator. And so we'll hear from Mr. Rawlings, and then we'll open it up for questions. Mr. Rawlings, you're up. Welcome.
Thank you. I appreciate being here today. I'll be very brief. I know it's been a long day for y'all, and I do have my written testimony. I do want to emphasize one point. This bill is not a gotcha bill. I think there's been some misunderstanding that somehow this is targeted at our wonderful child welfare folks who do that hard work every day. Having run the Georgia Division of Family and Children's Services and having had a bill like this in place for over 15 years now here, we find that the ability to share information with the public about what has happened in a particularly tragic case is actually really helpful to the public, to our legislators, to our policymakers. It builds public confidence in the system. These cases are already all over the news, so it's not as if we are somehow exposing something. We are actually giving the public better insight into just how difficult child protection work can be. And I really think this is something that I know agencies traditionally are a little bit afraid of releasing information. But as Senator James said, this is something that really is required by federal law. We see more and more states going this route. And I think in the long run, you will find that it helps to bolster the public's faith in the child protection system. And it helps the public better understand just how difficult it is to protect children. So I would also ask that y'all send this bill across the aisle so that perhaps I can talk about it over there as well. Thank y'all so much.
Can I add one thing?
Absolutely.
I'm so glad Judge Rawlings brought that up. It was in my notes, but I was trying to really condense it. I heard from almost everybody involved in this bill that I spoke to said, let me tell you what really happens. The information doesn't get out, rumors get out there, misinformation gets out there. And if you don't have enough information, or you have very little information, your mind, spirals, and you begin to think the worst. And actually, I've always believed that knowledge is power and truth helps you. So I totally agree with the judge that not giving them accurate information is doing far more harm, even if the department doesn't see it that way. I think that's really what's happening. Thank you.
All right. Thank you, Senator. Thank you, Judge. No questions from the committee? All right. Thank you very much, Senator. Thank you. With that, that'll conclude the hearing for Senate Bill 89.
Thank
We're
you
now
all.
going to Senator Sidnor with Senate Bill 182.
All right. Senator Charles Sidnor, Senate Bill 182. I have very simple testimony. This is the bill that we voted out of this committee unanimously. The exact same bill. Exact same bill. I was hoping there is a gentleman who was arrested in Baltimore County, and actually his story was reported in the New York Times earlier, and I was hoping that he was going to be here, but I don't see him. But again, this bill was voted out of this committee, unanimously voted out of the Senate, went over to the House and unfortunately died before it was able to get to us back on sine die. That ends my report. Any questions? All right.
Excellent. All right, that concludes the testimony for Senate Bill 182. We'll now hear from Senator Sidnor with Senate Bill 187.
All right, Senate Bill 187 is a reintroduction of a House, what was House Bill 747, which passed the House last session 131-4. But we heard it, but due to time constraints, I believe, it did not make it out of this committee. Senate Bill 187 repeals Section 9-515 of our Codes of Correctional Services Act, which authorizes incarcerated individuals to harvest crops at camps in Queen Anne's and other counties in its entirety. So the first iteration of this law, just to give a little history, was enacted in 1916 and allowed incarcerated individuals to work on public roads and highways in the state. Then in 1943, this body repealed and reenacted this law to continue authorizing incarcerated individuals to perform work on roadways and authorize the Board of Corrections to arrange for incarcerated individuals to work at camps, namely in Queen Anne's County, to harvest crops from August 1st through November 30th of each year. Finally, and this is the important part I want you all to hear, in 1999, the Correctional Services Article Review Committee noted that, and this is a quote, the General Assembly may wish to repeal this section as obsolete, as no camps existed in Queen Anne's County and no incarcerated individuals were being used in agricultural work as authorized by this section. Further, just to make certain, when I reached out to the Department of Public Safety on January 24th of this year, and they confirmed via email that these camps no longer exist. As Section 9-15 of our Codes Correctional Services article is antiquated law, I respectfully urge this committee to vote in favor of Senate Bill 187. That ends my testimony.
Well, Senator, thank you for bringing the bill forward. I learned something new tonight. It's incredible. Questions from the committee? All right, thank you very much, Senator. And with that, that'll conclude the hearing for Senate Bill 187 and our hearings for the day. Out of deference to the senator, I was going to reschedule, but if you're here and she's willing to do it, do we have permission from the senator?
Yes.
Okay, excellent. All right. So, all right, my apologies. Senate Bill 390.
No worries. I promise I will be quick. Good evening, Chair Smith, Vice Chair Waldstreicher, and members of the committee. I'm Natalie Lynch. I'm Senator Kelly's Chief of Staff, and as the senator is out sick today, I will be testifying on Senate Bill 390 on her behalf. I have Michelle Smith here with me as well, who is co-chair of the Legislative Committee of the Family Law Section Council of the Maryland State Bar Association. Senate Bill 390 is necessary to provide an equitable solution in child support determinations by giving courts the discretion to weigh, compare, and consider both the taxable and the non-taxable earned income of each parent in the same manner. According to Maryland Code Family Law Article, Section 12201, the courts must consider the actual income in determining the income of each parent for child support purposes. However, the income that the court considers for child support is currently gross earned income and does not include non-taxable earned income. The non-taxable earned income of a parent is not presently grossed up to be in alignment with the earned taxable income of the other parent due to Maryland case law, which Michelle will speak more about. The Maryland appellate courts have made it clear that the trial courts do not have discretion to adjust a party's income except as allowed by statute. So Senate Bill 390 will add some language to the definition of actual income to address the tax which would be paid on non-taxable earned income by a parent, therefore giving the courts the discretion necessary to weigh and compare the earned income of both parents in an equitable manner. So to further clarify this additional language, the Family Section Council of the Maryland State Bar Association has requested a friendly amendment. This is included in Senator Kelly's written testimony, and it's also available on the floor system too. Michelle will touch on that a little bit as well here today. The amendment will provide clear guidance to the trial courts as to the type of the non-taxable earned income, that the types of taxes that should be included in the calculation to gross up the earned non-taxable income for child support purposes. I thank you all for your time and urge a favorable committee report on Senate Bill 390 with the included amendment. Thank you.
Thank you, Chair Smith, Vice Chair Waldstreicher. I wish I had Slurpees or chocolate or something. Maybe we could do jumping jacks for a minute of my 2 minutes. I'm the last one standing and have been with you since 2 o'clock. My name is Michelle Smith. As you know, I've already testified and I was introduced here on behalf of the Maryland State Bar Association Family Law Section Council. This bill was brought to our attention. It's a cross-filed bill, so it was brought to our attention initially by the chair of the Family Law Section of the Judiciary Committee, and that is Delegate Crutchfield. This bill is important because the legislature needs to act in order to plug this hole with regard to child support calculations. I know some of you are aware of how child support is calculated, both with our Maryland guidelines, as well as for people who are above the guidelines making over a combined income of $360,000 a year. In both circumstances, if one of the parents or both is making non-taxable income. So an example of this would be somebody who works at the World Bank, who is an employer in DC. That employer employs some of our state residents in PG County, Montgomery County, surrounding counties to DC. They pay non-taxable earned income to their employees. So if a family is involved in a custody matter, child support needs to be calculated either as a settlement negotiation in a custody matter or in court in order to compare the W-2 income of one parent versus the non-taxable income, earned income of the other parent. You have to get those two incomes on equal footing. That could happen using expert testimony in court if that were permitted. Currently, it's not permitted. So we need a legislative fix, and you'll see in my written testimony that we have suggested an amendment. If I may, I'm sorry, it's late. The bill actually takes language from the DC statute and drops it into our statute for actual income. We have suggested, after taking a look at that statute, an amendment to very specifically state the components of grossing up that non-taxable income. And therefore, we urge a favorable report with the amendment, which is indicated in my written testimony. Page 2, line 23 through 25 would now say, for a parent with non-taxable earned income from an employer, the amount of federal, state, and local taxes and FICA, including any additional Medicare taxes that would be withheld if the earned income were taxable. Thank you.
Excellent. A little bit more room to run because you've been here since 2 o'clock. Questions from the committee, Senator Sidnor.
I'm looking at the language. I'm trying to read. I mean, I appreciate your context when I'm reading it. I'm trying to understand what are the practical implications of what it is that we're being asked to do. So I appreciate that, but then reading the language, it's not. Let me make certain I'm understanding. We're trying to capture taxes that explain it. No, I mean, I'm just want to explain it again because I read this. And it's not clear to me. It's not. Yeah, it's just not clear language.
It's very technical. So if two people are the parents whose incomes are going onto the guidelines or even off the guidelines analysis for court for child support, you understand the guidelines include in actual income for each parent as the top line. So that's the very first thing we need to figure out. So parent one works for the World Bank. They get a pay statement from the World Bank that says, for example, they make $100,000 a year. So we divide that by 12 and we put their income on the, say that's the the father's column. Mother makes W-2 income, okay? So her income, for her income, she's getting deductions for federal, state, local taxes, as well as FICA, which everybody understands to be Social Security and Medicare.
And the World Bank person isn't getting
World
these
Bank
deductions.
person's income doesn't have those deductions. So we're not comparing apples to apples. In order to get dad's income to be comparable to mom's income, the W-2 income, we need to gross up dad's income, which means add in the deductions he would have paid, so they're being compared apples to apples.
How many entities that this be applicable to?
Okay, so this is a great question. This bill is not like our divorce bill from last year, which is so fabulous, thank you all, which affects so many of our constituents, of your constituents. This is a small slice. It doesn't affect as many people, but it still matters to the children of those families. Because we're talking, you can't say exactly what the percentage of grossing up is, but in the neighborhood of 1/3, because the tax structure is such that it's, 12% at the bottom, 37% at the top, that that we're paying taxes on it depending on our income. So for those families, it matters. And the point is that there are 2 cases specifically that address this, where people have appealed on issues related to the fact that they weren't allowed to present this testimony. And the appellate courts of Maryland have said, you guys need to fix it, because we assume that you were very specific and detailed in your most recent overhaul of the child support guidelines. And that algorithm takes into consideration the fact that it assumes that we're using taxable earned income. So it has certain calculations that go on that work on an assumption that is not the case for non-taxable earned income.
So like, and I know I've heard where people may go overseas into conflicts and their income isn't taxed. Is this something that would be applicable to?
You mean military personnel?
Right.
This would be earned income. So if it's earned from any employer, then yes.
Okay.
If you're talking about something like, for example, VA disability benefits, no, because this is earned income.
Earned income. Right.
Yes.
Okay. Thank you.
And I just want to say to that point, to the point previous, that even if the parties stipulate, so if dad and mom in my scenario come to court and they say to the judge, we agree that dad's income should be bumped up 1/3, the court still is not allowed to consider that, even in the best interest of the child, even though the judge knows that's best for the child, because the child's going to be shorted some child support if they don't bump it up, but they're not even allowed to stipulate to it, because the courts assume that we here, you as a body, made the child support guidelines as detailed as possible, so there's no discretion to adjust it. Thank you.
I'm sorry, I've never heard that you used a W-2. I've done plenty of domestic cases, so, we look at the actual gross income.
Yes.
So, but you're saying you think the law is that a wife that has taxes taken out, you look at her post-tax?
No.
All right, well,
You're absolutely correct. No,
I'm
it's
sorry, I
gross
just heard you-
income. Yes.
Right, okay, I just wanted to clarify that.
Yes.
All right, thank you.
But when you put her gross income in, the child support algorithm in the guidelines is assuming that both people are making gross income for which they're paying taxes on. So it's not that the net is not used in the calculations. It is the gross for both.
I think it's silent. They just want your gross income.
That's correct.
Right. Okay. I'm gonna have other questions, but it is late.
Sure.
Thank you.
You're welcome.
Yeah, I'm sorry, I got caught off guard with something, but it's similar to what she just asked. I'm gonna kind of walk through the scenario you just mentioned. You said if you got, let's say, dad working at World Bank, I didn't realize they got no taxes or whatever, but if dad is making 100K working at World Bank and he's not paying taxes a certain way, and then mom is making 100K and she's a W-2 employee. Under current provisions of child support law, you have, when they're calculating, everything is based off of gross income.
Correct.
So if you end up doing a plus up to account for the taxes dad isn't paying, let's say you go up to 150,000, you're actually increasing the amount of child support dad has to pay when mom is making 100,000 and dad is making 100,000, because it's coming off of gross income anyway. So now you're saying, okay, so what's really happening is, from based off of what you said and how I'm understanding it, mom is at 100K, she's going, whatever, I guess just the increase will go to dad. He'll end up paying more instead of it washing out, because typically one party makes 100, the other party makes 100, and they got, shared time. Nobody pays child support. But if now you're saying, dad, you don't pay a certain amount of taxes, so that's 100K for you, 100K for mom, we're going to bump you up to 150K or 130K. Now you're forcing the other party to pay more when they both really make the same amount.
But they have different abilities. They have different amounts at the end of the day from which to pay child support. That's why it's reasonable to gross up dad in the best interest of the child. Because he has that extra money that he's not paying in taxes. So he has more ability to pay the child support in the amount. So the algorithm that the child support guidelines uses, the internal algorithm, should compare them at the same rates, how much they have to pay child support. Dad has more ability to pay because he's getting this money tax-free.
So what happens in a situation where you have, let's say dad is making 100K and it's tax-free, but mom, she's also making 100K, but she's a small business owner also. And so now mom comes in and she's able to write off just about her entire income. Is that now captured in this plus up as well?
Well, that is captured by the judge, and currently in the statute, there are provisions that apply directly to mom and what she's doing. Her expenses have to be reasonable. The judge has to make a decision, or the trier of fact has to make a decision as to whether her expenses are reasonable before deciding on the actual income to actually put in her column.
Okay.
Okay.
All right. Thank you.
Thank you.
Thank you, Mr. Chair. I just want to note for the record that the testimony of Senator Kelly accepts the State Bar Association's requested amendment as a friendly amendment.
Correct. It is a friendly amendment. I've been working with both sponsors on this issue.
Thank you.
It was a fascinating bill. Thank you.
Thank you.
Great, yeah. It was worth the wait.
Good night.
All right. All right.
Slurpees next time.
There you go. All right. With that, that'll conclude the hearing for Senate Bill 390 and our hearings for the day. See you all tomorrow.